And on a beautiful Saturday evening, this is Primetime, Bethea'S Byte Reloaded. Welcome one, welcome all. Ernest Bethea here, the last Outlaw. So good to have you all here. And I know I was kind of short in my description for this week, but yeah, I have a lot of different updates. But I also got SARAH Boone too. We'll get to her in a little while. But first, I want to bring to your attention a very long-standing missing persons case. Look to the left side of your screen. We're looking at Catherine Barbara Davidson. She also goes by the name Cappy. The FBI seeks to bring closure in the 50-year-old case of Catherine Barbara Davidson, who was just 6 years old when she was reported missing in Michigan on September 1st, 1973. The FBI's Detroit field office and Michigan State Police are seeking the public's assistance in locating Catherine Davidson. On September 1st, 1973, 6-year-old Catherine Davidson was reported missing at Warren Dunes State Park in Sawyer, Michigan. It is believed that her possible death occurred in the Chicago, Illinois area around the same time period. Kathy was 6 years old, as I said, at the time of her disappearance. She has black hair, brown eyes, but that's all the information I can give that I was provided with. There's nothing on height at the time of her disappearance, weight, what she was wearing, or what she was wearing at the time she was missing. A lot of gaps open, I know. But still, if you have any information regarding the whereabouts of Catherine Barbara Davidson, please, as always, do not hesitate. You're asked to call 911 or contact the FBI's toll-free tip line at 1-800-CALL-FBI, 1-800-225-5324. You can also call your local FBI office, or you can submit your tip online anonymously at tips.fbi.gov. Your diligence and information could be the difference maker in bringing closure to this case. You ask us, please share this information with someone who may have valuable information that could finally close this chapter on the life of Catherine Barbara Davidson. And as always, I want you to remember, if you see something, say something. That way we can do something. All right. I appreciate your attention to detail on that particular matter. Now, normally I would save all this for the end, but I want to get this out of the way now. First of all, again, I thank you all for joining me this evening. You want to support the channel? I've got there's a number of ways for you to do it. First, the free way is that you like, share, subscribe, and drop me a comment. Drop the comments so you can leave to me here in the live chat, or you can drop it in the community section, because I'll have this there as well. I look forward to it. You can join me here on the live panel. The live panel is always open, so I'm looking for you to be a part of this as well. You can drop me a tip in my PayPal, my Cash App, or Venmo. This is just to keep the channel running. It's to keep the channel running, whether it's for the software that I'm using or new equipment. It's all about keeping the channel running. So you can drop me a tip via PayPal at EKB316, Cash App, $ EKB316, or Venmo, EB the Last Outlaw. And as always, I am all over social media. So you can hit me up on Facebook, Bethea'S Byte Reloaded. On X, at EKB316, that's in all caps. On YouTube, at Bethea'S Byte Reloaded. On Instagram, this time it's all lowercase, at EKB316, lowercase, on Instagram. TikTok, Kingdom Hearts 316 2021, or you can email me, kingdomhearts316_09 at outlook.com. I appreciate all the support. Now, if you're ready, let's, like Eminem would say, let's get down to business. And we started off the week with news that the judge is delaying the sentence of murder defendant Wade Wilson to August. Wade Wilson will no longer be sentenced on July 23rd. That date is already passed. Hang on a second, guys. Yeah, Wade Wilson will no longer be sentenced on July 23rd. A judge ruled on Friday that the decision of life or death will be on August 27. In a last-minute court date for Wilson, his attorneys argued that doctors who will testify need more time. Kevin Shirley, one of the two in Wilson's defense team, says one doctor wants to do brain scans on Wilson. However, it would require deputies to escort Wilson to a facility. I don't know if he would be prepared to render an opinion as to whether or not my client had any organic brain damage without those scans, Shirley said. The examination will cost up to $10,000. In the meantime, that's only part. So that's part of the story. Let's go right back to Court TV. Let's go to Court TV for a breakdown of the change in sentencing for Wade Wilson.
Well, now we turn to the strangled women murder trial in Florida. Convicted murderer Wade Wilson was in court today for a motions hearing to delay his sentencing. Now, his attorneys say they need more time to prepare because they're still waiting for reports from their medical experts. Now, the judge didn't want to immediately hear from the attorneys. Instead, he called the doctors in question. Now, both are working on other cases. One of them is on the abused wife or murderer trial that Court TV is currently covering.
I was calling to find out, it appears, are you not available to testify for the Spencer hearing on Tuesday of next week?
No, I'm going to be in Miami for another case. It's actually a jail visit. I'm scheduled to see him in jail.
So it's not you're not testifying in court?
No, I'm not testifying now.
Okay. So could that be rescheduled so you could be here Tuesday?
It's very difficult to get things scheduled, changes with my schedule. And I just got a bunch of information on this guy, and I'm not really prepared to testify yet, so I just got everything.
When did you get everything?
2 days ago.
So you were appointed back in April. You haven't done anything?
Yes, but I never got anything until 2 days ago.
It looks like you've been authorized to be paid for these services. How long will it take you to complete the work that you've been paid for?
I haven't been paid yet, so no. I mean, I usually
okay.
I don't bill until I do the work. It's just out there until I do the work.
Okay. How long will it take you to do the work?
The opportunity to do that, and it saves me at Lee County, so I can do that on a pretty short time frame.
How short?
Because it's not a long distance. I would say 1 month at least. Oh, actually, probably more than a month.
He's in a trial.
He is? What trial is he in?
He's actually in Palm Beach. It's a murder trial.
Which case, do you know? Yeah, which case?
Marsha Thompson.
Okay. And you said it's in West Palm Beach?
Correct.
Okay. Do you know if he's supposed to be there all day today, or?
As far as I was told, he was supposed to be there at least. I mean, this was all day yesterday as well.
Okay.
He didn't even get on the stand yesterday. He was supposed to, so he was definitely on the stand today. It's actually on court TV if anyone is questioning what's going on. But he's supposed to be there. He told me at least for the morning. He told me to cancel all the morning.
Okay.
He didn't really tell me exactly what time they'd be finished. So when we tried to log on, the problem is that he's not approved as a professional visitor. So it would be recorded, which it can't be. So there is a way to get him to be a professional visitor. It's just impossible to get a hold of the jail to then approve him to be that visitor. So that's kind of the issue that we were having. And now I've done it before. It just takes forever. So it's more a matter of like either we need time or he doesn't see him and he just reviews the records, or, you know, that's kind of where we're at.
How long would it be before he could do this? Like, what's his availability to do that as well as to testify in court?
I mean, I would say I'm just looking, like I'm looking at August is not horrible. I mean, if we could get it situated, I mean, he has availability to do the evaluation, I would say first 2 weeks of August, and then usually it takes about a week for him to write a report.
Yes, Court TV cameras are everywhere. That person you just heard actually works with Dr. Michael Brannon. He's a forensic psychologist, and he's testifying in the murder trial of Marsha Thompson. We just showed you a little bit of his testimony earlier. Now, after the calls, the judge addressed the attorneys on both sides.
That gives me some more information then on what, I guess, has not been done.
Right. But at least with Dr. Brandon, that sounds a lot more feasible than the neurological examination.
All right, well, State.
Judge, as far as Dr. Brannon, his schedule seems reasonable. I think Dr. Rubino is someone who's, we should not continue over 30 days for him, given that he hasn't reviewed anything, and not only that, but he's wanting to order this expensive testing that's really not probably going to happen. JAC is likely not going to fund it, and to send him out to do MRIs does not seem necessary given the lack of evidence we heard regarding brain damage. To me, it's just a fishing expedition to try to say that he has some sort of brain damage when the records and all the evidence that came out don't support that. That's my opinion on Dr. Rubino. As far as Dr. Brannon, I would leave that to the court whether a continuance should be allowed for him to do his work and to testify.
Well, in the end, the judge reluctantly granted the motion to delay the sentencing and set it for August 27th. Now, last month, the jury convicted Wilson of killing Diane Ruiz and Christine Melton. Prosecutors are seeking the death penalty in that case.
And yes, now you see why I rely on Court TV for a lot of my coverage that I have here. Like Michael Ayala said, and I give thanks to him. And the case is reset for August 27th for Wade Wilson's sentencing, and one of the doctors that will testify as to whether Wade Wilson has any kind of brain damage also just recently finished testifying in the abused wife or murderer trial, which I have a verdict for a little later on in this broadcast. Next up, it's the latest chapter in the Karen Reed saga. Karen Reed briefly appears in court as the judge schedules a retrial. Monday, Karen brief court appearance for 6 days going forward. A high-profile case against her involving her Boston police officer boyfriend that ended in a mistrial earlier this month. Reed is accused of ramming into John O'Keefe with her SUV and leaving him for dead in a snowstorm in January 2022. Her two-month trial ended when jurors declared they were hopelessly deadlocked, and a juror declared a mistrial on the 5th day of deliberations. I have some commentary on that in just a few minutes. The judge will hear oral arguments on a defense motion to dismiss 2 of the 3 charges against her on August 9th, and a retrial was scheduled for January 27th. The hearing lasted just a few minutes. A boisterous crowd of several dozen, many dressed in pink and carrying signs claiming Reed is innocent, greeted her with cheers as she arrived at court. A smaller group of about 20 people dressed in blue came out in support of O'Keefe. In several motions, the defense contends 4 jurors have said the jury unanimously reached a not guilty verdict on 2 of the 3 charges against Reed, including murder. The jurors reported being deadlocked only on the remaining charges of manslaughter while operating a motor vehicle under the influence of alcohol, and trying her again for murder would be unconstitutional double jeopardy. The defense also argues Judge Beverly Canone abruptly announced the mistrial without questioning the jurors where they stood on each of the 3 charges Reed faced, and without giving lawyers for either side a chance to comment. Prosecutors described the defense request to drop charges of second-degree murder and leaving the scene of a deadly accident an unsubstantiated but sensational post-trial claim based on hearsay, conjecture, and legally inappropriate reliance as to the substance of jury deliberations. As they push against the mistrial, the defense also wants the judge to hold a post-verdict inquiry and question all 12 jurors if necessary to establish the record they say they should have created before the mistrial was declared, showing juries unanimously acquitted the defendant of 2 of the 3 charges against her. I'm going to stop right there, and I'm going to bring this to your attention. I know I've said this numerous times before, but I believe it bears repeating. In this type of a case, the jury says they're hopelessly deadlocked, but word is flying around that they were unanimously acquitting Karen Reed of murder and operating a motor vehicle while under the influence. If that was the case, then here's what I'm suggesting. Why didn't the judge ask both attorneys if they wanted to poll the jury on each charge? Not sure the process would be painstaking. I get that. But we would find out exactly where the jury are deadlocked on. All they have to do is go by one, ask that juror what was his or her verdict. It takes 12 to convict. It takes 12 to acquit. Anything less deadlocks a jury, which is a subject to mistrial. Wow. Now that, ladies and gentlemen, is pure common sense. That's it. Common sense. This is why a couple of weeks ago in her opening statement, Court TV's Julie Grant called this a debacle. And That's exactly what it is. And then if it wasn't the prosecution bungled some points, the defense bungled some points, but the biggest bungle, in my opinion, came at the very end. The jury is hopelessly deadlocked. On which charges, though? Let's find out. Ask the prosecution, would they like to poll the jury first? They say yes, then they'll say yes or no. Ask the defense if they want to poll the jury. They will say yes or no. Once that's done, you go to the jury with each charge. Ask each one, guilty or not guilty. Once that's done, then the judge can declare a mistrial with whatever charges are left after a full-on conviction or acquittal. Period. Meanwhile, we can get ourselves prepared this winter, because come January 27th, it's going to be round 2. The Commonwealth of Massachusetts versus Karen Reed. Alright, let's move on with the Black Swan murder case. Florida versus Ashley Benefield. There's a lot of days recap. So I'm going to take you through all 4 days as quickly as possible.
When Doug and Ashley Benefield met, they both had been married previously. Now, not a lot is known about Ashley's first marriage, but Doug had just lost his wife Renee 9 months before meeting Ashley. Then, their romance actually blossomed via text messages because Doug was traveling for work. And when they got back together, they quickly got married within 13 days of first meeting. 54-year-old Doug, an entrepreneur, was now married to 24-year-old Ashley, a former ballerina. Together, they started a ballet company in Charleston, South Carolina. But as they were launching this expensive venture, Ashley got pregnant and moved to Florida to be with her mother. From that point forward, the relationship became very strained. Ashley accused Doug of abusing her and stalking her, and Doug accused Ashley of preventing him from seeing his child. This battle was fought inside family court, and each time Ashley lost. Then the judge ordered psychological evaluations of Ashley and Doug. The results of those evaluations were going to be revealed in court, but just a few days before that hearing, Ashley shot and killed Doug. She claims self-defense, but the prosecution says it was murder. Tonight, we are live from the courthouse in Manatee County, Florida for day 1 of the Black Swan murder trial.
I'm Vinnie Politan. Thanks for joining us here tonight on Closing Arguments. As we talk about this case, Doug and Ashley Benefield, it really begins with a very bizarre custody battle. A custody battle that really began before their child was even born. Before the child was born, the litigation began. It usually doesn't happen that way, but it did in this case. And the question is, well, they're in South Carolina, right, doing all of this. Why are they in Florida? Why is this all happening in the Sunshine State?
Why did that happen? Well, we know Ashley went down there because her mother was living there. And the real question for this jury will be, well, why is Doug in Florida? Why is Doug there? Is he there because he wants to get back with Ashley and he's obsessed with her and he's following her wherever she goes and he's stalking her? Or is he in Florida because his wife, who may be his estranged wife at the time, is about to give birth to his daughter? And he wants to be a father to his daughter. That's for the jury to figure out, because you've got two competing narratives throughout the course of this case, throughout the course of this trial. And the questions for this jury really go to the two people who we're talking about, the defendant and the victim. And we begin with Doug Bethefield. And the question is this guy an abuser, or is he just a guy who wants to be a father? Is he obsessed? Is he violent? Is he unpredictable? Does he fly off the handle? Is he dangerous? Or is he a guy who got married to a woman that he thought he was in love with and thought that loved him, and she's carrying a child and has a baby, and he wants to be a dad to his baby? Those are the two pictures. Those are the two choices. That's what the jury has to figure out here. That's what is really at issue. And then with the defendant herself, Ashley Bethefield, well, is she a killer, like a cold-blooded killer, or is she a victim who is defending herself? A victim of his violence, a victim of his abuse. That's what this case is about. That's the way it's been set up. Joining us right now, live from Manatee County, Florida, Court TV, legal correspondent Kelly Craft. Kelly, great to see you. Yes, jury selection is technically the beginning of a case, but I think today, days like today, are really the first day. So let's talk about the scene at the courthouse, what's going on there, and then tell me about the opening statements.
Good evening to you, Vinny. Yeah, it really is basically the first big day, and the state had a busy day because not only, as you mentioned, opening statements took place, but the state went through so many witnesses today, and it was a little bit surprising because they went through them pretty quickly. They said that they actually are a little bit behind schedule in calling witnesses. But the scene inside the courtroom, so you have a lot of supporters for the victim in this case, Doug Bethefield. So we've heard from his cousin. His daughter took the stand today as well. Two of his older brother and a younger brother has been here inside the courtroom. Some other supporters, including a longtime friend and other cousins. So a lot of supporters for Doug Bethefield. On the other side, for Ashley Bethefield, her mother has been here, but she's going to be called as a witness. So she has been sitting outside the courtroom. Also inside the courtroom, we've seen some people who have been at prior hearings in this case. For instance, the Stand Your Ground hearing. Some of those people have been inside the courtroom for this case so far. And also some people who stand against domestic violence. So interesting to see the different crowds inside the courtroom today here in Manatee County, Florida, in Bradenton. Why don't we go ahead and play a little bit of the opening statements. Obviously, two very different pictures here. The state painting a picture of a manipulative woman, and then defense counsel saying that this is just a case about self-defense.
This case is about a woman who very early on in her pregnancy decided she wanted to be a single mother. And she did not want the father of this child to have any visitation, her husband. And everything she did from that point on was to attain that goal. And she would stop at nothing to attain that goal. She tried several things in the system that you'll hear. The courts, law enforcement, Department of Children and Families, no one got on her side. And at the end, when there was no other option, she shoots him and kills him and claims self-defense.
Fearing for her life, she heads for her bedroom where she has a firearm. She gets to the firearm, she turns around, she orders Doug to stop. When she looks up, he's in the doorway. Instead of seeing the gun and leaving, Doug gets into this warrior pose with his arms moving purposely and advances. At that point, petrified, she fires, believing that if he gets a hold of her, she will be either seriously injured or killed.
And Vinny, also in court today, the state played the redacted version of that 911 call when Ashley Benefield went over to her neighbor's house and told the neighbor what had happened, that she had shot and killed her husband. So bits of that played today inside the courtroom. And so that was interesting to kind of watch the jurors' reaction to that. And also they passed around a number of crime scene photos. Some jurors definitely looking at those a lot more closely than other jurors. Vinny.
And we're going to break down that 911 call coming up in just a little bit. But let's talk about one of the first people I spoke to when I started covering this story, which is Doug's daughter. Not the little child who was outside of the courthouse the other day with the sign for her mommy, but her daughter, Eva Benefield, who testified today. How about her testimony?
Vinny, so she was on the stand talking about the relationship that she would observe between Ashley and her father. And she talked about a moment when Doug came to her and said that he had met someone, that he was dating someone, and also wanted to talk a little bit more about it at one point. And she told her father that she actually didn't really feel the need to sit down with the both of them and want to talk with both of them until they came to the point where they were going to be getting engaged. And to her surprise, they had already been married, and that's what her dad ended up telling her. But she was asked on the stand on direct examination about what did she observe in regard to their relationship. Did she notice any discord? And then also on cross-examination, she was asked about a hole that was in the ceiling. Let's go ahead and listen to those.
How often would you say that Ashley and your father would disagree within your hearing?
Never.
Okay. You said if Ashley was trying to get her point across that she would go on and on about that?
Yes.
Okay. So you don't term that as a disagreement?
No.
Okay. And what would you term that as?
My dad just listened to her voice her concerns.
Okay. Did you ever hear your dad at any time yell at her?
No.
Did you ever hear your dad do something or say something that was controlling to her?
No.
Was that hole in the ceiling of your kitchen, can you describe it?
It was small.
Small, kind of round?
Yes.
Consistent with an object?
Objections, speculation.
Let me finish the question.
Consistent with an object the size of a bullet?
Yes.
So, Vinny, in a prior hearing for the Stand Your Ground hearing in which Ashley Benefield, was talking about these past allegations, these past incidents of her husband that she was alleging, talking about things like him pointing this gun into the ceiling and firing it, also punching a hole through the drywall in their home. And so Eva was asked loosely about some of these incidents because she, of course, on direct examination was talking about never noticing anything, no discord, but then on cross, defense counsel was able to get some of these incidents out there.
Yeah, trying to paint a picture that this was like a house of terror that Ashley Benefield was living in. We'll see if it's effective in front of the jury. Tommy Benefield also testified today, first witness called in this case, and he's Doug's cousin, been very outspoken and really one of the driving forces to try to get justice for his cousin. How about that moment inside the courtroom?
He had a lot to say about their relationship as well, Vinny. And one of the things we've heard a lot about in this case so far is that both Doug Benefield as well as his wife Ashley Benefield both had a love for guns. And so this was a little bit of Tommy's testimony talking about where Ashley kept a gun. Let's listen.
Did Ashley ever discuss with you that she carried a gun?
Yes.
And what did she say about that?
She said that on their initial meeting, in the political meeting, that she and Doug's traveling partner in business went outside of Secret Service people, and she showed him the gun she was carrying at that event in her bra.
And that was the night they met, and then about 13 days later, they ended up getting married. This is Ashley and her husband, Doug. So interesting to see and hear what's going to happen as things transpire in this case, Vinny, and some late-breaking word today. We heard this earlier, that the state is planning to rest on Thursday. So this case is moving a lot more quickly than we had thought.
Oh, it's super fast. You could tell. I mean, witnesses on and off, important testimony, important witness after important witness, and we could be in a verdict watch on Friday. So, Kelly Craft at the courthouse. We'll speak again tomorrow. Thank you so much. All right, I want to bring in a Doug and Ashley Benefield both had been married previously when they met. Not a lot is known about Ashley's first marriage, but Doug had just lost his wife Renee to an undiagnosed heart condition. Renee died 9 months before Doug met Ashley. And after they met, their romance blossomed over text messages because Doug was traveling overseas for work. And when he got back to the U.S., he got together with Ashley, and they quickly married. In fact, they were hitched within 13 days of meeting. 54-year-old Doug, an entrepreneur, married to 24-year-old Ashley, a former ballerina. Together, they started a ballet company in Charleston, South Carolina. But as they were launching this expensive venture, Ashley got pregnant and moved to Florida to be with her mother. From that point forward, the relationship became very strained. Ashley accused Doug of stalking her, and Doug accused Ashley of preventing him from seeing his child. This battle was fought inside family court, and each time Ashley lost. Then the judge ordered psychological evaluations of Ashley and Doug. The results of those evaluations were going to be revealed in court. But just a few days before that hearing, Ashley shot and killed Doug. She claims self-defense, but the prosecution says it was murder. Tonight, we are live from the courthouse in Manatee County, Florida for day 2 of the Black Swan murder trial. I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. And, you know, the Constitution gives us a whole bunch of rights. And one of these rights I rarely exercise, but Ashley Banfield did. Banfield. Ashley Banfield doesn't either. Ashley Benefield did, which is the right to remain silent. Like, you don't have to say anything. You never have to say anything. You're being questioned by police, you don't have to say anything. You shoot someone, you don't have to say anything. So usually when we think about that, we think about it in terms of being questioned by police, right? There's like an interview room, an interrogation, body cam, whatever it is. You're being questioned by law enforcement, and maybe you're involved in something like a shooting, and you decide not to say a word. Criminal defense attorneys will tell you that that's what you're supposed to do. But what if you don't tell anyone else? Like no one else. You just shot someone, your husband, and you don't talk about it with anyone else. Well, I think that's what's going on here with Ashley Benefield. She has not told her story, which is amazing because this is a self-defense case. And usually in self-defense, you explain to whoever's asking, oh yeah, it was self-defense. They were coming at me. I had to save my life. It was so scary. I thought I was going to die. But that didn't happen here. She remained silent, completely silent, didn't tell anyone, didn't tell her mother. Now, Doug Benefield was shot by Ashley. We know that. He won't speak, he won't say anything about this, but he's on trial right now also. In a self-defense case, a victim ends up on trial. We've seen it many times on court TV. Some people look at it and say it's really an unfair advantage because the victim can't speak for his or herself, and Doug can't. But that's the way self-defense works. She'll have an opportunity, but she hasn't said anything yet. So to me, the biggest mystery surrounding or over this entire case is what will she say when she does speak? What will she say? How will she say it? Will she be emotional? Will she be credible? Will the jury believe her? Will the folks in the court of public opinion believe her? It's going to be a huge moment. I expect it to happen in this trial. The only thing in this case that will absolutely shock me is if she doesn't get on the stand to tell her story for the very first time. Today was day 2, another big day down in Manatee County. Let's go down to Bradenton, Florida, where Court TV legal correspondent Kelly Craft is tonight covering all of this for us. Kelly, great to see you. Let's talk about today. This is going to be a quick trial, we know that. So we are sort of in the middle of the case already here on day 2, but tell us some of the big moments today.
Yeah, moving along really quickly. Good evening to you, Vinny. So a lot of key witnesses took the stand today. I heard you mention her mother. So her mother took the stand, as well as several other people that were really important to the state's case, and the defense counsel probably scored some points as well. But another big thing that took place today is this dynamic that we've been watching and observing between defense counsel and the judge in this case. At one point, the defense counsel, Neil Taylor, just said, I'm calling for a mistrial, Your Honor. And this was after he made a ruling on an objection. And Neil Taylor just said, I am calling this because Ashley Benefield has been continually denied her right to cross-examine witnesses. So she is being denied her right to a fair trial. And seeing the judge's reaction to this, he was so nonchalant. He said, motion denied. Let's bring in the jury. So watching this, at one point, Neil Taylor said to the judge, I think I'm going to be deserving a whooping or something like that. So the judge even said to him, I hope you're aware, and I believe you're aware of the decorum that is expected inside a courtroom. So a lot of big developments today, a lot of key witnesses, and I know we're going to talk about them, Vinny.
Hey, let's talk about Ashley's mom. I think she's such an important part of this story and this case and this trial and what happened, because she is the one that Ashley went to. She left Doug, she left South Carolina, went to be with her mom, has remained with her mom. What about her testimony today?
Yeah, and that's so important because Ashley did. She went and wanted to be with her mom because she said that she was extremely sick during her pregnancy, and really her mom would be the only one that could take care of her. Her mom was also there on that day prior to when Ashley ended up shooting and killing her husband, Doug. And so she was asked about being present before the child, Emerson. This is the daughter that Ashley Benefield and Doug had together. They asked about what her reaction was before and why she ended up going to the park with Emerson. Let's take a listen to that testimony.
How far away was the park?
It's a short walk. I mean, we'd always walk over there, so I don't know. It'd take us maybe 5 minutes to get there.
Okay.
So.
And on this particular day, I think you told Miss O'Donnell, if I'm not mistaken, you were actually in the process of going with Emerson to the park when Doug arrived?
Yes. We're walking down the driveway and I had her in the stroller.
And on this particular occasion, there was nothing unusual about you going to the park, just like you did regularly?
Yes.
So, Vinny, defense counsel wanting to get across, like you heard there, nothing unusual about going to the park that day, because the state has kind of suggested that the reason they ended up going to the park is because Ashley Benefield knew what she was about to do and then sent them away to go to the park.
Which makes it a plan. Right? She's planning and plotting this. That she's making sure that her mom's not there, but more importantly, that their daughter isn't there when all of this happens. So I guess you could look at it two ways of the two of them being alone in the house. Either it's part of the plan, so she can do it without having to do it in front of her daughter and not making her mother a witness to this. Or number two, from the defense perspective, that, hey, Doug got her alone, and this is when she was the most vulnerable, when she was alone with her alleged abuser. And speaking of domestic violence, a domestic violence detective also testified today.
Absolutely, Vinny. And I think some of this testimony was probably the most damaging to defense's case, because what he talked about is the number of times that Ashley Benefield would call him. But what he would say in regard to that is she kept insisting to have him arrest her husband, Doug, inside a courtroom at a court of law, because she, according to the testimony today, was saying to him, that's really going to help in my child custody battle here if he is arrested inside a courtroom. Why don't we go ahead and play some of this detective's testimony?
She started crying again and came out with a comment, something to the effect of, I can't believe you're willing to allow Doug to kill me and the baby.
And at some point, did she change from crying again?
She did.
What did she do?
It just abruptly changed, and she let out like a screech or a high-pitched scream. And she says, I'll do whatever I have to do to kill my baby or keep my baby, you.
And I just think that's something that the jurors here, Vinny, are really going to remember his testimony, because he was talking again about how she repeatedly kept calling, asking for her husband to be arrested. And then finally she says, you're going to just let him kill me and my baby. And he said that he'll never forget that, because he's really never heard anyone get that excited and say something like that in all of his years after they called so many times. And then the level just kept increasing because he was not arresting him inside a courtroom.
That's such a, and this is one of the issues the jury really has to decide about, right? Is she setting him up because she's in this custody battle and her goal is to keep Doug out of her daughter's life? Or is she the actually scared and a victim of this monster, Doug Benefield? And that's what this case is coming down to. Two people on trial, but only one of them is alive. Kelly Craft, live down in Manatee County. Looks like this thing could end this week, so we will speak again tomorrow.
Yeah.
Thanks so much, Kelly.
Yeah.
Ashley Byers was just 24 years old when she met 54-year-old Doug Benefield. Doug was a widower who lost his wife Renee 9 months before he met Ashley. But in just 13 days, Doug was no longer single, and Ashley's last name was no longer Byers. It was now Ashley Benefield. Together, the couple lived in Charleston. Ashley was a former ballerina, and she wanted to start a ballet company. Together with Doug, they launched a ballet company featuring dancers who didn't fit the prototypical ballet dancer profile. But as they were starting this expensive venture, Ashley got pregnant. She then moved to Florida to be with her mother. From that point forward, the ballet company imploded and their relationship became very strained. Ashley accused Doug of stalking her, and Doug accused Ashley of preventing him from seeing his child. This battle was fought inside of family court, and each time Ashley lost. Then the judge ordered psychological evaluations of Ashley and Doug. The results of those evaluations were going to be revealed in court, but just a few days before that hearing, Ashley shot and killed Doug. She claims self-defense, but the prosecution says it was murder. Tonight we are live from the courthouse in Manatee County, Florida for day 3 of the Black Swan murder trial.
I'm Vinny Politan. Thank you so much for joining us here on Closing Arguments. Great to have you with us. We're in the midst of another murder trial here. This all coming on the heels of the case involving Karen Reed up in Massachusetts. I know all of you very invested in that case, and that was a case that was a 3-month murder trial for Karen Reed. Not 1 month, not 2 months, but a 3-month murder trial for Karen Reed. This case, though, a little different. Get most of the evidence in, not in 3 months, but in 3 days. So here we are in a case that is moving at a rapid speed. Now, the question is for prosecutors, will this lead to a speedy conviction? And it's amazing when you think about it. The charges are the same. It's murder. Karen Reed was accused of running her boyfriend over with a car, and on the other hand, you had Ashley Benefield, who's accused of shooting her estranged husband. Both serious charges, both murder cases, but completely different tempos to these cases. One's in Massachusetts, one's in Florida. That accounts for part of the difference here. So as prosecutors attempt to move forward in this case to a speedy conviction, the defense is looking for a quick acquittal. One or the other, unless we get deadlocked again, will happen in this case. But let's find out where we are. Joining us tonight from Bradenton, Florida, Court TV legal correspondent Kelly Craft, who's been covering this case from the beginning. Kelly, great to see you. Where are we right now in this case?
Hi there, Vinny. Well, the state has rested, so that was the big news today. They had said earlier in the week that they did expect to rest sometime this week. They thought they would do so around lunchtime today. There were some issues earlier in this morning that delayed proceedings a little bit, but then they ended up resting later on this afternoon. And then after they rested, defense counsel made a motion for a judgment of acquittal. So arguments took place from both the state as well as defense counsel, and the judge ended up denying that judgment, that motion for a judgment of acquittal. So then that means tomorrow, Vinny, defense counsel will begin presenting its case.
Yeah, and you know, there's always that big question looming as soon as that happens. The question that we always want to know, will she or won't she, should she or shouldn't she? We will find out if she's going to take the stand. But today, what I thought was really interesting is we got sort of a snapshot into this relationship between Ashley and Doug Benefield through some text messages that were shown in court.
Absolutely, we did. And it's funny, we cover so many cases, you usually get some juicy text messages. Not so much in this situation. Really, they were doing a lot of exchanging of pleasantries. Good night, good morning. Doug Benefield was sending Ashley Bible verses, and then she would just love the image, put the little heart, send that back. So several Bible verses, pleasantries, talking about court proceedings, and then this move that was going to be taking place. So he was telling her that he was going to go to Lowe's doesn't get moving boxes. And then the testimony was about, this was from the person, the sergeant who did the cell phone extractions. Really just, he talked about the last exchange, the text message exchange between Doug and Ashley. Let's go ahead and listen to that.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two?
Correct.
Okay, so after okay, 1 minute, what is said?
Then 2:59, about to head back from Doug, and then the message after that appears to be an attachment at 5:11 in the afternoon. Appears to be maybe the U-Haul truck that they're loading up.
Okay. And that was sent from Doug?
That was 5:11. Yeah, that was incoming, yes, from Doug to Ashley.
Okay. And then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and tutu cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
So, Vinny, nothing really groundbreaking or that thrilling about the text message exchanges between the two of them. The state really just wanting to establish that, this was the last text message exchange between both Doug and Ashley.
And it paints a picture. Things seem very normal, very cordial. He's rented this U-Haul. He's packed up his stuff, I guess, first, and then he's driving over there. Trucker on the way, that's him, to go pack up stuff at their house. It's not like a prelude to a murder here. There's nothing unusual about it. I get why prosecutors want to put this in front of the jury. Another witness today that I thought was extremely important in significance here, since there is only one person alive who was there at the time of the shooting. You try to get some sense of what happened there, and I guess the best that the state can do is bring in the medical examiner to talk about the wounds and the trajectories of the bullets.
Vinny, this is Dr. Vega, so the medical examiner who took the stand today. And the state's theory, what the state has talked about in this case, is that the bullet was side. It went from side to side, the right side to the left side. Now, defense counsel is saying that no, it went into the chest from the front, and then maybe even if it was a little bit off to the side, still it was from the front. So what he's saying, defense counsel, is that the pistol was facing right at the front, his chest, the chest of Doug's. And he did get the medical examiner on the stand to say, yes, that pistol would have been pointed toward the front of the chest. Why don't we go ahead and listen to some of that testimony?
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest. There was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
Okay. And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we'd call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
So, Vinny, that's really where the difference is coming in between the state's theory and defense counsel. Again, you heard the medical examiner talking about it, saying to the right side of the chest. Defense counsel saying, yes, pointed at the chest, where the state is saying, no, Doug was turned away and it went into the side. So kind of saying that he was running away. There's no way that he was going after Ashley.
That's the only evidence so far that this jury has about what could have potentially been happening there. Because Ashley Benefield hasn't testified yet. If she does, she'll give her version of it. We heard it from her attorney, but that's not evidence in the case. So this is extremely important. Okay, there was a little jury drama today. Can you explain what happened this morning?
I sure can. So this morning things got delayed a little bit because an attorney sent a letter to the court saying that they represent someone, a particular person. And so what was going on here is someone had noticed a juror at a restaurant, and at that particular restaurant there was a news program on in which the proceedings of the court were being addressed, and this particular juror was there. So what happened is defense counsel then wanted all the jurors to be polled as to their media consumption. Let's take a listen to that.
Judge, I would suggest respectfully all the jurors, and I think
even though the letter says it was a male juror.
Yes, because that's what this anonymous source said. But I think to be safe, to the extent there was some jurors in this location, there's limited places to go for lunch around here, Judge, so I think there's potential that there could have been other jurors there as well.
I'll bring them in individually to ask about that.
So, Vinny, the judge went ahead and polled all the jurors. One after one said, no, it wasn't me, it wasn't me. And then we finally got to the person who said that was me. And that person ended up saying that, yes, noticed something that was on. It made him feel uncomfortable. He ended up taking his lunch to go and just ate it outside the courthouse. And so that was about the end of that. Polled the jurors. Nothing really ended up happening. Got that situation cleared up. And then the court proceedings officially began.
Yeah, every time there's a little bit of drama, I get very worried that things could be happening. But it seems like you're just going to pick up your lunch. The place you pick up your lunch has got a TV on. Yeah, they're talking about it. I don't want to see that. I'll get that to go. And so much ado about nothing, hopefully. Kelly Craft at the courthouse tomorrow could be a big day.
I'm sorry, there's a big accident just right in front of us. Sorry.
Okay, yeah, okay. All right, so I'll let you go. Make sure everybody's all right. Call 911 if you can.
Okay.
Wow, right there. Years old when she Ashley Byers was just 24 years old when she met 54-year-old Doug Benefield. Doug was a widower who lost his wife Renee 9 months before he met Ashley. But in just 13 days, Doug was no longer single, and Ashley's last name was no longer Byers. It was Benefield. Together, they lived in Charleston. Ashley was a former ballerina, and she wanted to start a ballet company. Together with Doug, they launched a ballet company featuring dancers who didn't fit the prototypical ballet dancer profile. But as they were starting this very expensive venture, Ashley got pregnant and moved to Florida to be with her mother. From that point forward, the ballet company imploded, and their relationship became very strained. Ashley accused Doug of stalking her, and Doug accused Ashley of preventing him from seeing his child. This battle was fought inside family court, and Ashley was not winning. She was losing. Then she told Doug she wanted to reconcile.
while she secretly had no intention of ever getting back together. Doug went to her house to help pack for a mutual move to Maryland, a move which did not happen because Ashley shot and killed Doug. She claims self-defense, but the prosecution says it was murder, and now, for the first time, Ashley Benefield tells her story in front of the jury. We'll break it down and examine her body language as we are live from the courthouse in Manatee County, Florida for day 4 of the Black Swan murder trial.
I'm Vinny Politan. Thank you so much for joining us tonight here on Closing Arguments. We've seen a lot of self-defense cases here on Court TV, and we've seen some people be very successful in these cases. Let's take a look. Remember Kyle Rittenhouse? Big case out of Wisconsin. Took the stand in his own defense. There was also some video evidence in that case. But at the end of the day, he told his story. The jury believed him, and he was found not guilty. Just recently on Court TV, you saw it. Marsha Thompson told her story, and it was similar to Ashley Benefield's, talking about abuse. And guess what? The jury bought it, and she was found not guilty. Also in the state of Florida, Curtis Reeves, remember him, retired police officer, same area in that Tampa Bay area of Florida, was inside a movie theater and shot and killed the man he was getting into an argument with after popcorn was thrown on him. He told his story to the jury, and he was found not guilty. Well, today was the day for Ashley Benefield. She told her story, and the jury, it's not that the jury's out. The jury hasn't gone out yet because the trial is still continuing, but the jury got to hear everything that she said, and that raises the questions. Did they believe what she said? Does her story make sense? Is she credible? Do they believe her? Let's take you right inside the courtroom because I want you to see and hear some of the most important testimony, which is Ashley Benefield talking about the moment she shot and killed her estranged husband, Doug.
I ran.
Where?
To my room.
Why?
Because I was scared.
Ashley, did you have anything in your room that could protect you?
I had my gun.
Did you grab the gun?
Yes.
As you're grabbing the gun, what, if anything, did you hear?
I heard the door hitting the doorstop.
As if it is flung open?
Yes.
And what do you see, Ashley, when you look up?
Doug was standing in the doorway. His face was red. Like the veins were bulging in his neck. The way he was looking at me, it didn't even look like Doug. His eyes were black.
Does he yell anything at you?
He said, "You're done."
What does he do at that point?
I held the gun like in front of me, and I said, "Stop." And he like turned and he got into this like a fighting stance. I got low and he started like moving his arms and his hands around. He was making these like jerking motions.
What were you expecting when you were holding the gun out in front of you and you told him to stop?
I thought when he saw it, he would leave.
Did he?
No.
At that point, Ashley, what are you thinking?
I thought he was gonna kill me.
Tell us what happens next.
He started coming towards me, and then he lunged at me, and I started pulling the trigger, and he just kept coming, and I remember trying to move to get away
Ashley, would you tell us why, if you're holding a loaded firearm, you were attempting to move away?
I was trying to get away from him. I was terrified.
All right, so you're firing. He keeps advancing. What happens next?
It was like his feet slipped out from under him and his legs went up in the air.
When Doug hits the floor, what's your immediate reaction?
I ran to get help.
Can you tell us how many shots you fired?
I have no idea. I was in a panic.
Everything at stake. Everything at stake. This becomes the case when the defendant takes the stand, especially in a self-defense case. This is it. They are judging her. They are judging her story. What a big moment. Let's go right to Bradenton, Florida, to the courthouse. Court TV legal correspondent Kelly Craft joins us on this huge day in the Black Swan murder trial. Kelly, great to see you. Describe that scene for us. This is such a big, big day today with Ashley Benefield taking the stand.
Well, hi there, Vinny. Big day. And we didn't really know if she was going to testify in this case or not. Defense counsel has been very tight-lipped about this. So when he called her as the second witness today, it was very quiet inside the courtroom. Everyone, of course, anxiously anticipating to see what she is going to say on the stand. And I was watching the jurors as she was testifying, and there's one person in particular that is taking a lot of notes, one of the younger jurors taking so many notes. And some women, when she was talking, when Ashley was describing what was taking place, I noticed one in particular really shaking her head in agreement, like she was agreeing or understanding what Ashley Benefield was talking about. But it was a big moment when she got up there and she started to talk about exactly what took place. As you just heard and all our viewers just heard her describing those moments that she shot and killed her husband. Some of the testimony also today was the moments preceding that shooting. Why don't we go ahead and listen to some of that testimony?
What was your response, Ashley, after being struck by the cardboard box?
I apologized.
Why would you have apologized?
Because I could see how upset he was, and I didn't want him to get more mad at me.
Where does Doug go after that incident?
He continued to the garage with the box.
And what happens at that point?
We started getting into a back and forth about being done for the day and what still needed to be packed and that I wanted to be done. And we ended up in our daughter's bedroom, and he started screaming at me. He said, "Shut the up." He started calling me names. And he said, "I can see what you're doing. You're trying to get me to leave." He said, "I don't have to leave. I can stay and spend the night if I want to because I'm your husband."
And Vinny, it was really interesting to watch her give a demonstration, especially on the cross-examination, when the prosecutor asked her to stand up and to demonstrate exactly what she did, how Doug was acting, and she was really questioning her, the prosecutor, on how Doug's hands were. Were they fists? Were they like fists coming at you, or how were they? And Ashley was saying they were just kind of going back and forth like this. So watching that demonstration and watching everyone in the courtroom watch that demonstration, that was a sight to behold as well.
It's a big moment because the jury heard the testimony about the trajectory of the bullet. So how does her reenactment or description jive with that is a big, big issue for this jury. Wow. Reminded me a little bit of Jodi Arias years ago. Juan Martinez, the prosecutor, had her stand up and describe. In that case, there was a lunge as well. Let's talk about another part of this case, and I've been saying this, we've all been saying this from the beginning. Ashley Benefield's on trial, but because it's a self-defense case and the nature of this case, Doug Benefield has been put on trial by the defense. And I thought there was some damaging testimony, if the jury believes it, about Doug and Doug and his dog.
Certainly, Vinny, yeah, and this kind of testimony doesn't exactly sit too well with a lot of people, because Ashley was talking about Doug, his behavior, and them getting into some disagreements, and how the dog got in the way, and then he ended up punching the dog. And so those can be pretty damaging remarks about her husband, and how then things like that could escalate into eventually really hurting her or her eventual child that she shared with Doug. Let's play some of that testimony in which she's talking about this dog incident.
We were having an argument, and he came at me like he was gonna hit me. And our dog, Sully, jumped up in between us, and he punched him in the face so hard that he knocked him out. I just remember screaming because I thought he had killed him.
Were there other times that Doug hurt the animals?
Yes, he had kicked, punched Sully. He threw our cat multiple times. Sometimes he threw Snuffy down the stairs.
So defense counsel really getting Ashley to talk about a lot of these incidents on the stand that eventually go along with his theory of how things just kept building up over time.
And I understand that. The thing that's a little different about this case is, at the time of the shooting, they're not together anymore. They're living separately, and he's invited to her place to help her pack, which adds another dynamic to what was happening here. So let's get into that relationship. There were more text messages that the jury got to see, and to get a little more insight into the nature of what was going on in this relationship.
These text messages came out pretty early during the testimony, Vinny. And so what she was talking about is how they met. She used some adjectives to describe Doug, that he was caring, they wanted to be together all the time. And then after they were married, she went on a cruise with her mother and a girlfriend. And then she said while she was on that cruise is when she started to notice things being a little different, and some of the text messages that Doug began sending her. Why don't we go ahead and play those for our viewers?
Knowing you were taken advantage of still in my mind makes me explode with anger to take them out. God made you for me. You haven't seen the warrior side and never want to. We went from joy and passion to now I'm in a testosterone rage inside. But kill the bad people. How long had you been married when you received these texts from Doug?
I believe it was about a month or so.
And so that's what defense counsel was getting across on the stand with Ashley, that they were married, and then immediately, within about a month, Ashley started seeing this other side of Doug, Vinny.
There's another witness I didn't know about that testified today, someone who heard the gunshots and saw Ashley Benefield. What was that testimony about?
Yeah, she was one of the last witnesses that we heard from today, and then eventually the jurors were sent home because there was a hearing as to whether this domestic violence expert is going to be testifying on Monday. But this woman you're looking at right here, she took the stand, and she was talking about hearing the gunshots and running out of the house. Let's go ahead and listen to her.
You say you heard some gunshots.
It sounded like gunshots.
All right. Now, After you heard the gunshots, did you observe anybody exit a house?
Quickly, as we were trying to make sure of our safety, we saw someone leave the house, a lady leave the house. It was, I mean, I don't know exactly, like timing-wise, because it's like I said, my mind was going through a lot of things.
Let me just keep you on the questions, okay? I'll help you. I'll lead you through it. You hear the gunshots. The next thing you see is what?
A lady came from the house and
describe.
I remember screaming, and that's just the vivid recollection and memory that I have. Just the screaming, and came from the house running to the neighbor's house. I don't remember too much other than the screaming and pounding on the neighbor's front door.
Is it a safe bet for us to say that this lady that you saw exit the house screaming was hysterical?
Yes, yes.
And so, Vinny, getting across that was just a very tense moment for Ashley Benefield, the witness on the stand, saying that she was hysterical. So she testified soon thereafter after Ashley Benefield took the stand. And so kind of watching the different dynamics inside the courtroom once Ashley got off the stand was interesting as well. But just some takeaways, too, when Ashley was on the stand. Eva, Doug's daughter, did not like some of the things that Ashley Benefield was saying on the stand. So at one point, she got up and walked out of the courtroom. Very clear she was not happy about some of the things that Ashley Benefield was saying. And then even watching Doug's family members in the courtroom, they were shaking their heads in disagreement with a lot of the things that Ashley was saying on the witness stand.
Kelly Craft live tonight in Manatee County. Rest up this weekend. Big week next week as this trial wraps up. Thank you so much.
Just said thanks to him and Kelly Craft. This trial could wrap up sometime during the next week, and Bethea'S Byte Reloaded will have coverage recapping each day's testimony all the way to closing arguments and possibly a verdict in the Black Swan murder trial. Speaking of another case to recap, we have another ongoing trial right at the moment. This is the wife stabs husband murder trial. Massachusetts versus Christina Ricci. And we got there's a lot to cover here. And this is just day one. So instead of me trying to wrap all that up, I'm just gonna go ahead and give you the 17-minute version of everything that went down in this particular case.
Good morning, ladies and gentlemen. It's been a few days for some, so I just want to begin by reintroducing ourselves to you. My name is Shannon Buckingham. With me throughout the course of this trial is Jeremy Kuzman and Jason Haran, and we represent the Commonwealth in this case. In this case, you're going to hear about Christine and Michael Ricci. The Riccis lived in Marshfield. They have 3 kids. Angel is the oldest. And Angel is not Michael's biological child, but you'll hear from Angel that Michael was his dad. The middle son is Michael Jr., and the youngest child is Sophia. And you will hear from them during the course of this trial. You're going to hear about Michael. Michael grew up in Hyde Park. Michael was a military vet. He spent 22 plus years with the Boston Fire Department. You're going to hear about the defendant, Christine Ricci. She was, for all intents and purposes, a stay-at-home mom, but she also taught Zumba, and around the time of this incident, she was taking classes at Quincy College. The Ritchie family was a seemingly happy suburban household. But ladies and gentlemen, we never know what happens behind closed doors inside a household, do we? You'll hear throughout the course of this trial from people inside the house and outside the house about how the Ritchie household changed over the course of time, how the defendant changed, how Michael changed. You hear about the major turning point in their marriage that occurred in the fall of 2018. Michael had an affair. It was a brief affair, but it was an affair with another woman. And the defendant knew or found out about it. For a short period of time, the decision was made that Michael was going to leave the marriage, possibly leave the household. But quickly, the decision was made for them to stay together and work on their family and stay together as a family. Michael messed up. But from the time that he told the defendant about the affair, he did everything he could to try to make things right and keep his family together. He worked on himself, he went to AA, he worked on his relationship with his children and his wife. He did everything his wife asked him to do. The defendant, on the other hand, continuously talked and focused on infidelity for over 2 years. For over 2 years, her inability to get over that affair increased. You will hear testimony throughout the course of this trial from witnesses about verbal and physical altercations by the defendant against Michael. You will hear witnesses describe how the defendant would control Michael. They will tell you about seeing black eyes, fat lips, scratches on his face, and a broken nose. You'll hear that the night in question, January 28, 2021, is not the first time the defendant brought a knife to an argument. This affair was like a pot of water simmering on a stove. And over the period of time between 2018 and January of 2021, the defendant continued to turn up the heat on that pot by bringing up that affair over and over until that simmering pot of anger, jealousy, and control boiled over on January 28, 2021. So January 28, 2021, it's a wintry Thursday. There was still snow on the ground. Michael was home that day. You will hear that his work schedule was a work 24 hours on, get 2 days off, work 24 hours on, and get 4 days off. And so on this day, Michael was on the 4-day stretch of having some days off, so he was home. The defendant was home. Their daughter, Sophia, had gone to school and was home in the afternoon. Angel was at work that day. And during this period of time, Michael Jr. wasn't actually residing in the home, but he was close by and available. On this particular afternoon, Michael goes to Dunkin' Donuts in the afternoon, gets a coffee, comes home. He's doing some shoveling outside before coming into the house, meeting the defendant, his wife, in yet another argument. The children will testify and tell you that arguments were frequent in the household and that arguments were always about the same thing, the affair. On this particular day, Sophia will tell you that she could hear her parents arguing when she was up in her room after school, but that was pretty much normal for her at that point. On this particular day, it was particularly loud, and she did everything she could to try to tune them out. Until later in that afternoon, when her mother, the defendant, yelled her name, yelled for her to come down. Sophia comes down the stairs, goes into the area in between the dining room and the living area to find her dad on the floor and the defendant standing over him. The defendant tells her to call 911. Sophia calls 911. You're going to hear the 911. You're going to hear Sophia's testimony about what she recalls that day. The Marshfield police arrive at their home on Moraine Street. They're the first ones to arrive, you'll hear. And when they arrive, the defendant tells the first officers that Michael suddenly collapsed. So the officers that arrived begin to tend to him by giving him CPR, and almost a few minutes later, paramedics arrive from the Marshfield Fire Department. And they take over care of Michael, continuing with CPR, trying to resuscitate him and get him in a condition to take him to the hospital. When the paramedics put Michael into the back of the ambulance, they again try to stabilize him, and it's at that point where the paramedics discover, after cutting away his shirt, that Michael has a stab wound, a deep penetrating stab wound in his chest. When they remove the clothing, you'll hear, they find another injury, another wound to the rear of his arm near his shoulder. The paramedics immediately advise the police, who are inside with the defendant, and it's at that point, and only that point, you'll hear, that the defendant tells the officers that she had been in an argument with her husband, with Michael. She tells him she was scared, she grabbed a knife to scare him, and that when he lunged at her, the knife just went in his chest. Throughout the course of this trial, ladies and gentlemen, you're going to see those injuries. You're going to hear about those injuries. You're going to see pictures of Michael, how tall he was, how big he was, where those injuries were on his body. You'll hear that there's more than one stab wound. There's two, but there's in fact 3 injuries that are noted on his body. The stab wound to his chest, the wound to his shoulder or the back of his arm, and what will be described to you, I expect, as an incised wound, which is a large scratch along his back. You will see that there were 2 knives located in that house that day that had Michael's blood on the blade. The first was located on the floor by where his body lay, where he was laying when first responders first got to the scene, and one in a box on the dining room table with several other knives. You will see pictures of those knives. You will see pictures of the house and where those items were located when the police were at the house that particular night. You will hear from a medical examiner in this case more about that fatal chest wound and what the details of that wound, how deep it was, what kind of injury it caused, what damage it did to Michael's body, and what resulted in his death. We ask, ladies and gentlemen, that you listen carefully to the evidence and keep an open mind. And that's something you're going to hear us say, you'll hear the judge say, you'll hear everyone say it again and again throughout the course of this trial, but it is paramount in this type of a case that you listen carefully and keep an open mind. And that you not forget that you, as a group, bring to this case your common sense and life experience when you evaluate the evidence. And we ask that you do that as you continue to listen to the evidence in this case. And the evidence will tell you what happened in the Ritchie household that night on January 28th, 2021. At the end of this case, we will return and ask that you find the defendant guilty of murder and assault and battery with a dangerous weapon, because the evidence will prove to you beyond a reasonable doubt that she is in fact guilty of those crimes.
Thank you. Next we'll hear from the defense. Attorney Wood.
Christine Ritchie never intended to kill Michael Ritchie on January 28, 2021, and the Commonwealth doesn't have any evidence to prove that she did. The argument that occurred that was just described to you, the confrontation that was just described to you, all of that information all happened during about a 15-minute, small 15-minute pocket between 4:30 and 4:45 on January 28th, 2021. And every answer to every question that we have about Christine's intent, Michael's intent, Michael's last actions and Christine's actions are contained and sealed in that 15-minute pocket. And ladies and gentlemen, that's probably why the Commonwealth is going to spend such a small amount of time talking about that 15-minute period, because they want to distract you. Christine's words are really the only evidence that we have of what occurred during that 15-minute pocket. And those words, remember, were spoken in the moments after all of these events happened. It's true that she doesn't give a complete statement of everything that occurs, and as we go through the evidence in this case, and when I come back and talk to you at the end, I'm going to suggest to you, through reference to both the forensic evidence as well as putting together the statements, about what probably happened around and between the details of what it was that she said. When the police arrive, the evidence is going to be that Christine Ritchie is absolutely beside herself. Absolutely beside herself. She is crying, she is heaving, she is hyperventilating. The first responders come to the scene and she can get almost nothing out. She says he collapsed, that comes out. The Commonwealth wants it to be the case that that means that she told some sort of misleading statement. The evidence is going to show that she gave an incomplete statement and that maybe she wasn't in a position where she even could give a complete statement. She was just too upset. After Michael Ritchie's body is removed from the house out to the ambulance, there's going to be evidence from an officer by the name of Chris Martin, who's going to say that at that point they sat her in a chair and they asked her what happened. While the body is still out at the ambulance, while they're so-called discovering the stab wound that you just heard a moment ago. And the evidence is going to say that when she's confronted at that moment about what happened, she gives a little bit more detail, but she's still extremely upset. She's so upset, in fact, that she actually takes some medication to try to calm her down. But as she begins to say the details of the case, she mentions the knife, and she mentions the argument and the fact that it escalated. And that's going to be supported by the testimony of Sophia Ritchie, who heard that escalation of the argument into a screaming match. And it's true, she does say, I held the knife out, and then at another point she does say, he lunged at me. And at another point mentions being attacked. And I'm going to suggest to you that the evidence will be that even when Christine said those words, that wasn't everything that happened. And at that point, the evidence will show she may not have had a complete memory of what had just fully occurred. But Christine Ritchie's words are the only direct evidence that you're going to have about what happened between 4:30 and 4:45 p.m. on January 28, 2021. They're the only eyewitness reports of what happened. And they don't at all support the story that the government just told you. And that is probably why they are going to spend the entire case discussing things that didn't occur during that period of time. I expect that they are going to parade a bunch of witnesses in, remote friends of Michael Sr., who are going to be allowed to offer their opinions about the defendant, that they are going to pick along a 2.5-year period, a series of isolated events, and try to string them together to create the most damning possible picture of who Christine Ritchie is. And that they will do so because they hope that you will be so distracted by the question of whether Christine Ritchie is the type of person that would commit this crime, that you'll forget that the real question is whether she actually did it. As I say, at the end of this case, we will hear forensic evidence. We will come back and we'll tell you a little bit more about what happened in January 28, 2021 in the absolutely critical 15-minute period. Talk about the mechanics and what's suggested. And a lot of it will be inference by inference, because we won't have that type of eyewitness testimony beyond someone's statements that was very, very affected by what had just happened to them. But what emerges from that is a very, very different picture altogether. Now, the Commonwealth wants you to tell you these stories about the past and about the affair. And it's true, there's going to be a story about an affair, and it's going to be a big part of the Commonwealth's case. This was an affair that took place in 2018. And a lot of the events that they're going to talk to you about physical confrontations, happened within just a couple of months of that event, maybe anywhere from a 6-month to 9-month period after that event. You're going to hear about other events that happened in the subsequent 1.5 years. Things like Michael going to AA, Christine supporting him in going to AA, him getting sober, him getting counseling, Ms. Ritchie getting separate counseling, them going to couples counseling, them reaffirming their vows in Hawaii in 2019. And you're going to hear from all of the children, and although they're going to say that there was fighting still and there was a fair amount of marital discord, they're not going to describe the type of events that were occurring in 2018. But the Commonwealth wants to sort of string these things together from 2.5 years earlier to try to pretend that that says something about Christine Ritchie in 2021. I'm going to ask you not to be distracted, to focus like a laser on the relevant period of 4:30 to 4:45 on January 28th, 2021. And I want you to be extra vigilant every single time the Commonwealth tries to distract you and talk to you about ancient history and tries to tell you about who Christine is and why you should believe bad things about her, and focus on what do they actually know about what happened on January 28th, 2021 between the hours of 4:30 and 4:45. And if at the end of the day, what you're left with is, I just don't know what happened, which is exactly where they are, then I'm going to ask you to find Ms. Ritchie at the end of this case during closing not guilty.
And that was the opening statements for this trial, Massachusetts versus Christine Ritchie. And to recap everything that went on day one, 20-year-old daughter Sophia Ritchie testified that her parents' relationship was fraught with arguments after her father divulged his affair to her and her brothers. The afternoon of January 28, 2021, she was in her bedroom when she heard the two yelling. Then her mother calling her and telling her to call 911. She found her daughter on the floor. She continued to testify after the 911 call was played. She was the only other person in the house at the time of the fatal confrontation. On cross, she agreed that her father was an admitted alcoholic who drank every day and experienced lapses in memory that was often the subject of her parents' arguments. He stopped drinking after the affair and attended AA meetings. Prosecutors would call Angel Ritchie the eldest son. He was adopted by Michael and has only known him as his father. Angel testified that he walked in on one of his parents' arguments, observed things were broken in the room, and described his mother as being so hysterical she went to the kitchen and grabbed a knife and attempted to stab herself in the stomach area. Angel said his father worked together to stop his mother from harming herself. On cross, Angel agreed his father was an alcoholic and drank heavily. Also on cross, Angel agreed that he would expect his father's DNA to be on kitchen knives because he used them. The case continues on next week. Moving on, we have an update in the case of missing and pregnant teenager Mia Campos. The ex-boyfriend of a pregnant teen whose body was found by her parents in the woods is in custody. According to police, 16-year-old Mia Campos left her Loganville home on the evening of July 14th with an unknown person. Hours later, her parents became worried when she didn't return home and used a cell phone tracking app to locate her. What they found was a parent and soon-to-be grandparent's worst nightmare. Their daughter's body was discarded in a patch of woods about 30 to 40 feet off a residential road. They immediately called 911. Investigators arrived around 1 a.m. and began processing the scene and speaking to witnesses. At first, the cause of her death was unclear. An autopsy completed the following day determined the matter of Mia's death was a homicide. Mia's ex-boyfriend, 20-year-old Jesus Monroy, was arrested on July 17th for providing false statements to officers. Although Monroy is being held in custody without bond, murder charges have not been filed, and the case remains open as police continue to investigate. Gwinnett Police urge anyone with information related to this case to come forward. Detectives can be reached at area code 770-513-5300, 770-513-5300. For those who wish to remain anonymous, tips can be submitted through Crime Stoppers at 404-577-TIPS. It's 404-577-8477, or on the website at stopcrimeatl.com. Crime Stoppers is offering a cash reward for information that leads to an arrest and indictment in Mia's case. A makeshift memorial was visible from the road that runs in front of the location where Mia's parents found the body. Flowers, cards, and stuffed animals surrounded a white cross with the names Mia and Sebastian etched into it. A GoFundMe campaign has been created to support Mia's family and cover up her funeral expenses. And all I can do from here is pray that justice is done, and if Jesus Monroy is found guilty, let the punishment be severe. Next up, Donna Adelson is back in court for the first time since January. Let's take you to Court TV for a brief word on Donna Adelson's return to court for the first time since January.
Times can take a little longer, as I know last time it changed a couple of times before trial, just minor changes that he made. We were able to keep defense up to speed with that, and had agreements as to that. We've talked about that and intend to do the same thing this time if we could have the deadline of September 4th for our demonstrative exhibits. We can give him a pretty finalized rough draft of that by that point, and any minor changes that do need to be made, talk to the defense about that after that time.
All right. If the defense can explain why you would like this to be pushed back, and the only reason I ask this question is because once everything is filed pursuant to the deadlines, we need to have probably at least a 2 or 3 hour hearing on all pretrial motions, so I don't want the start of the trial to be bogged down by needing a ruling on a particular issue or motion, but I'll allow you to explain.
Judge, I think the construction of some of the demonstratives, obviously I'm new to the game, so to speak, but in this case it is a different case factually from those that you've tried before. But just the construction of them, meshing them with electronics that we're going to have available, I would just like, we've got some new discovery in recently as well. That is going to be incorporated into our demonstratives, so it's just a little bit more reading room to be able to get it done.
And I assume both sides are going to want the headsets and the various audio media aspects for the jury once again?
Yes, sir.
Very well. Then going back to the order setting the procedure dates and also the deadlines as far as any demonstrative exhibits, then I will permit both sides to have until September 4th to ensure all demonstrative exhibits are traded between the two parties. As far as the witness list and the exhibit list itself, there's really no reason why August 12th that cannot be met, correct?
That's fine, Judge.
That's correct, and we would like it to be so and maintained. Likewise, Judge, we do have an agreement with Ms. Kappelman with respect to some of the exhibits and the manner in which they're listed. By way of example, example, Don Adelson emails, but it won't be more specific than that in the prior listings.
Mhm.
So we've talked to Ms. Appleman about being more specific when they're listed, with the understanding and the caveat that that would be a rolling list that could be supplemented, the exhibits could be supplemented. It's just to bring focus to, rather than digging through 50 hours of recordings or 5,000 emails to draw everything focused. So you don't need to do anything on that. That's what our agreement is. But on our August 12th deadline would remain the same for everything with the exception of the demonstrative.
All right. Do we need to address the modification to the trial date any further as to September 17th being the first day of selection?
No, sir.
All right. Time-wise, I would expect we're probably going to be similar to the last trial where we have at least 3 days or 4 days of selection. Assuming we are successful, we would get started, and then we would have about a week or maybe a week plus of trial. Do the parties have a differing expectation of this?
We sketched out the number of witnesses, and some of it is will be more focused once we get to August 12th, but I had some concern based on the volume of witnesses that we had agreed on. We were solid 2 or something.
Well, good thing I help everyone along in this process.
Now, that may drastically contract, because there are several of the witnesses that are very, very short, and there are simple things that we may even arrive at stipulations to knock those things out of the way. But I would be leery of telling you that it would all fall within the confines of 1 week. I feel like 2 weeks we could push hard for.
Okay. Well, you have until August 12th, I should say, to iron out aspects of this. Ms. Dugan, at least preemptively, would you expect the state's case to last for about a week once again?
Yes, sir. And I think last time, or the last 2 times, we have been able to pick a jury in 2 or 3 days, and the state's case took about 5 days. I would expect for it to be about the same.
Very well. Are there any other issues that either party needs to raise for the status as of today?
Judge, we're going to be filing several motions, some of which you've never heard before, and some of them are going to deal with, for instance, just so the other side knows, we are going to move to preclude Sergeant Corbett's testimony, which will obviously affect the demonstratives, but we think we can do that even without seeing the exhibit. But one of the motions that we intend on filing, I just want to let the court know of beforehand because it might affect scheduling of courtrooms. We're going to ask that the trial not be in this courtroom.
For 3G?
What's that?
For this courtroom, 3G?
Yes, we're
Go
going to
ahead.
ask that the trial be held in your courtroom 3B. And we have a variety of reasons why we think that courtroom will afford our client better due process than this courtroom does. And so we're filing that motion, and we'll file it on time. But I just want to give you a heads up so that if there's a scheduling issue, you're aware that that motion is going to come down the road.
Very well. Really, until I can see the motion and the state makes its argument, I won't be able to make a ruling on it, and that'll happen in time. As far as selection itself, though, we may still need to use this courtroom just to hold the sheer volume of prospective jurors that are needed, but as to the courtroom the trial will occur in, that certainly we can address with a motion.
And the motion, I should have said that, the motion contemplates that jury selection would still be.
Right. Ms. Dugan, any additional matters the state needs to address for today's hearing?
No, sir.
Very well. To go back to the scheduling order, our next set of deadlines will be discovery on August 12th, the motion filing deadline August 12th, the witness list and exhibit list also on August 12th. And I believe our pretrial hearing, not referring to the motion hearings that will be filed, but just the final pretrial will be September 12th at 9 o'clock. Mr. Morris?
With the advent of some of the new discovery, we're endeavoring to take a few depositions. Ms. Kaufman wants him to again be able to coordinate this by Zoom if necessary because of travel and things of that nature. The reason I bring it up, there's probably a chance that there are depot dates that are going to be after the August 12th date, but they will be set and noticed at that point. I hope that we
Set, noticed, meets the deadline, hopefully, so this doesn't become a similar issue like it did last time. If we need to address a particular aspect of discovery that needs to occur, possibly after the 12th, go ahead and move in advance for that so it does not become an issue of anyone violating the deadline or attempting to take or seek discovery after the deadline is passed. Okay? All right, with that being said, this status is coming to an end unless anyone has anything else you need to bring to my attention.
Nothing, sir.
All right. Ms. Adelson, were you able to listen and follow along to my discussion with the attorneys?
I could hear you. I could hear nothing that the attorneys were saying.
All right. I really can't ask them to repeat themselves in full, but your counsel have asked to set back one of the deadlines to September 4th. I have agreed to do that concerning demonstrative exhibits. All other deadlines are going to remain in place. They will speak with you concerning any other issues that you need to discuss with them about today's status, okay?
Okay, thank you.
All right, we are in recess. Have a good day, everyone.
Okay, some dates to remember now. Between the two parties, they have till September 4th to ensure all demonstrative exhibits are traded between the two parties. All other deadlines remain in place, meaning the witness list, exhibit list itself must be presented by August 12th, which is the deadline for all motions of discovery. Aside from a series of motion hearings that are expected to come up, a final pretrial hearing is set for September 12th. Jury selection on track to begin September 17th. So we're still waiting to see what comes up next, and how a jury will end up finding Donald Adelson when she goes to trial. Now, next up on the docket, a sad case involving one tool, not just adults, but kids use as well. A 12-year-old allegedly smothering her 8-year-old cousin over an iPhone. I want everyone to pay attention to this one. A 12-year-old girl in Tennessee has been charged with murder, accused of smothering her 8-year-old cousin as the younger girl slept. A relative said they had been arguing over an iPhone. A security camera recorded the killing inside the bedroom they shared on July 15th in Humboldt, Tennessee, according to the county prosecutor. The recording shows the older child using bedding to suffocate her cousin as the younger girl slept on top bunk. Gibson District Attorney Frederick Agee's statement said to this effect. After the child died, the juvenile cleaned up the victim and repositioned the body. A relative told WREG-TV in Memphis that the girls had been arguing over an iPhone after coming from out of town to stay with their grandmother. The girl was charged with first-degree murder and tampering with evidence after authorities obtained the video on Wednesday. I consider this to be one of the most disturbing violent acts committed by either an adult or juvenile that my office has prosecuted, Agee wrote in a statement. He said he would petition a judge to prosecute the girl who turns 13 later this month in adult court, which will allow for a lengthier sentence, whatever that will be, through incarceration or supervision with court-ordered conditions. 12 years old, smothering an 8-year-old over an iPhone. I never thought I would end up reading an article like that, but here we are. I'll wait and see what develops in that case, and when I get new information, I'll bring it to you. We have another case that's gone unsolved. A popular chef's 2016 murder remains. Michael Bates Jr., a well-known chef in Baltimore. Well, he was. He is remembered as a man who had an infectious personality. Nearly 8 years ago, his life was cut short as he was murdered at just 46 years of age. Not a day goes by where Erica Richardson doesn't think about her brother. Every day I wake up, she says, I wake up with Michael on my mind. And throughout the day, there's something that reminds me of him. She says that he had a larger-than-life personality. He was always the one to make you laugh. He was always the life of the party. Even if you were at a funeral, he would find something to make you laugh about. However, that all changed on September 21st, 2016, when her brother was murdered. Baltimore City Police say at least 2 people tried to rob him while he was sitting in his car. He put his hands up to comply with their demands, but was still shot in the neck. Police found him in the stairwell of a nearby building where he ran after he was shot. However, he died in the hospital shortly afterward. Erica Richardson then said, "In the morning when I got that call, and when I can hear my aunt say Michael's been shot, just pray. And to this day, it still feels like it just happened, and sometimes it feels like it's so far away." It's been 8 years, 8 years too long, and for his mother and aunt to go to their grave without closure and without peace is unacceptable, longtime friend Martin Jones said. Jones still feels the pain of Bates' death. He knew him from high school. Both went to the military. Bates went to the Navy, and Jones went to the Army. They reconnected years later and maintained a close friendship until Bates' murder. His legacy is his infectious personality and the way that he just walked into the room and became the center of attention and left everyone in stitches at the end of the day, Jones said. Richardson and Jones have a plea for the community. I would just plea again to the public that anything you know, anything you heard, just come forward and say what happened. There's someone that knows, and I hope they come forward and tell the truth to give the family some peace. Before Bates' death, he had plans to open up a culinary school and help veterans. Richardson says her mother died a few years ago with a broken heart due to Bates' death. I am going to echo that plea.
Sorry, I'm not sure.
Anyway, that was my Alexa app responding to the word echo. But anyway, I'm going to repeat that very same plea. If you have any information on the death of Michael Bates Jr., contact your local authorities. Let them know what you saw happen. Let's give this family some closure as to what happened to their son, their friend, their brother. If you've seen something, say something so authorities can do something. All right. We go to the abused wife or murderer trial, which I was talking about just a little while ago. And we have a verdict in that case. So, after 4 hours, 39 minutes and 16 seconds of jury deliberation, the verdict is in. Let's
Jury entering.
Please be seated. Has the jury selected a foreperson?
Yes.
Juror number 7, are you the foreperson?
Yes, ma'am.
Has the jury reached a verdict?
We have.
Please fold the verdict in half, hand it to the deputy, who will give it to me. Madam Clerk, please publish the verdict.
In the Circuit Court of the 15th Judicial Circuit Criminal Division and in 4 Palm Beach County, Florida, case number 19 CF 7582, Division U, State of Florida versus Marsha Thompson, verdict, not guilty.
Deputy, stop it! Stop it!
Yep, you heard it. With all the cheering and everything, Marsha Thompson, a U.S. Customs officer, has been found not guilty of first-degree murder in the shooting death of her husband. Thompson was charged in the August 2019 death of Terry Thompson at their Florida home. An arrest report from the Palm Beach County Sheriff's Office states an officer noted 6 bullet wounds on Terry's body and fired 9 fired shell casings in the living room. The couple's 2 children were home but didn't witness the shooting. Marsha claimed the shooting happened after Terry threatened to slit her throat and kill her during an argument, and in the arrest report the officer wrote, "I do not believe Terry Thompson posed such a threat that deadly force was necessary." In court documents, Marsha's defense claimed she acted in self-defense and was suffering from both battered spouse syndrome and post-traumatic stress. A judge previously denied her motion to dismiss charges under Florida's Stand Your Ground law. Basically, guys, Marsha Thompson did what she had to do to survive, and the jury's verdict backed her up. I'm gonna say again, like many have said before, you do not have to be a victim of battered spouse syndrome, intimate partner violence. You don't have to be a victim. Help is just a phone call away. Pick it up, and the number is 1-800-799-SAFE. 1-800-799-7233. There's someone available 24 hours a day, 7 days a week. They're able to speak to you in over 150 languages. Help is available. You don't have to be a victim, and you don't have to be a statistic. Remember, that's the number to the National Domestic Violence Hotline, 1-800-799-SAFE. And as far as the not guilty verdict, I can actually say that justice was indeed served. Moving onward. A man is charged after his girlfriend dies jumping from a car during police chase. Ain't this something? An Arizona man is facing multiple charges after a woman died when she jumped from his car. Authorities said 54-year-old Deborah Murrieta called police on last Saturday evening to report a domestic violence incident involving 36-year-old William Holloway. According to a news release, Murrieta said she was in the car with her boyfriend driving, and that he refused to pull over and let her out after he had taken an illegal drug. Deputies with the Pima County Sheriff's Office attempted to pull the car over, but Holloway refused to stop, leading deputies to chase his car at varying speeds up to 45 miles an hour. The pursuit ended when Murrieta jumped from a moving car. Authorities said she died at a local hospital. Holloway's car was later found with a flat tire. He was taken into custody last Sunday evening on multiple charges, including first-degree homicide and domestic violence kidnapping. This is another one of those stories I can say more information when I can get it. And in another highly charged case, one that's been talked about for quite some time, this is the Sonia Massey case. Prosecutor says the body cam shows deputies shoot the woman who called 911 for help. Police body cam footage released on Monday shows the shooting of Sonia Massey, a black woman from Springfield, Illinois. 36-year-old Massey called 911 early on July 6 to report a possible prowler. Sangamon County Sheriff's Deputy Sean Grayson and another deputy arrived at the scene and entered the house. State's Attorney John Milheiser alleges that Grayson instructed Massey to move a pot of water that was on the stove. Grayson then allegedly drew his pistol and threatened Massey, who apologized and ducked. Grayson allegedly shot her 3 times. Let me take you to Court TV.
Now for what's trending in true crime. An Illinois woman is dead after calling police to her home for help. According to the sheriff's office is reporting 36-year-old Sonia Massey was shot in the face by a sheriff's deputy named Sean Grayson on July the 6th. Police say that she called 911 to report a suspected prowler. When entering her home, the 2 deputies are seen engaging with Massey, having discussion with her. Everything was very pleasant before granting her permission to move a boiling pot of water that was steaming from her stove. Let's take a look together at what happens next.
I don't know where my ID is.
You just in that stack right there, maybe?
Okay. 1 second.
Check on her.
Let me get this.
No, we don't need a fire while we're here.
All right. Okay. Let me see. Okay. Where you going?
Huh?
Where you going?
Away from your hot steaming water.
Away from my hot steaming water?
Yeah.
Oh, I rebuke you in the name of Jesus. I rebuke you in the name of Jesus.
No, that's where I got. I'll shoot you right in your face.
All right.
Shots fired! Shots fired! Shots fired! Drop pop!
Now, Grayson has since been fired from the sheriff's department. He is now facing charges of first-degree murder, aggravated battery, and official misconduct. This morning, we're asking, what aren't we seeing in that video that's important for us to know? I have two tremendous guests. I'm going to bring them in now. I want to welcome in trial attorney and the former president of the National Bar Association, attorney C.K. Hoffler, and retired FBI special agent, firearms instructor, and former SWAT team member, Jennifer Coffindaffer. Great to see you brilliant ladies this morning and have you both able to weigh in from your various areas of expertise in law and law enforcement. So let's take these in turn, talking about the incident itself and then what comes next now that this case is in the criminal justice system. Agent Coffindaffer, would you start us off, please? Talk to us a bit about what you're seeing in this video and what you're most curious to see that we're unable to see from it.
Well, good morning, ladies. First of all, I think it's very important to see how quickly everything escalated here, when in fact law enforcement has they must de-escalate situations. She goes and removes this water, and then I believe she makes it colder because they talk about the steam coming off. That's what I gleaned from this. And it doesn't seem that she says, "I rebuke you in the name of Jesus" to these officers, but rather sort of says this. This is a training situation, I think, from the standpoint these officers don't recognize seemingly that she really isn't a threat, and they completely escalated the situation and shot when they absolutely had no authority to shoot, in my opinion.
Agent Coffindaffer, thank you for that. And now the county has presented it to a grand jury. They've issued a true bill. This officer is fired and facing charges. C.K. Hoffler, to you next, please. Would you take it from here as this progresses through the legal system? Your thoughts on the video and what the video doesn't show as well.
Well, good morning. The video is probably the most compelling piece of evidence that we know at this point. It does show the escalation by law enforcement versus the de-escalation. It shows the culpability of law enforcement, and so I think it's a very, very powerful piece of evidence. This evidence will be used in the criminal case against this officer. This is so very tragic. I've got to disclose, Ben Crump is a very good friend. He's my co-counsel on a number of cases. I saw him a couple days ago. We were at the National Bar meeting. We talked about this case. This is so egregious. This woman really was not a threat on any level, saying, "I rebuke you in the name of Jesus," and her tenor, her tone, her body language was not threatening at all, yet this officer somehow thought that she was threatening him with a pot of water. And so this is a clear example, Julie, I think of a case that for sure is going to go to trial. And I would predict, even based on this limited evidence that I've seen, which is the video that speaks volumes, I predict there will be a conviction if he doesn't plea out. This is horrific. It's extraordinarily disturbing, and this is it really causes goop. Whenever I see this footage, I feel very, very, very troubled that this has actually happened to this unfortunate young lady.
I appreciate your comments so much, CK. Thank you for that, and for the mention as well of the possibility of a civil suit, too. As you noted, your colleague and friend Ben Crump is representing the Massey family, and so the legal problems for this fired deputy probably won't stop with the criminal case. There's going to be civil action as well. CK, do you know, has anything been filed yet? I'm not sure if he might have mentioned that, or sometimes the idea is wait until the criminal case plays out.
Well, I think that there's some additional information. This is my understanding now. It's been about 3 days or 4 days, but they're waiting some additional information. But for sure, this is going to be a very significant civil case. I think it's a very strong civil case. A lot of times when you have these excessive use of force cases, you may not have all the evidence to be able to launch a very strong civil case. But this is a very strong civil case with the evidence that we've seen thus far. And there's probably more evidence that we haven't seen.
Point well taken, CK. We want to know what more is there, what more, you know, with that vantage point, there's a portion of it we can't see. So certainly the more information about this, the better. Agent Coffindaffer, one last question for you, please. Just out of curiosity, when The officers are there looking at this objectively, with the training that you have. What would have been the better thing to do for them if they were fearful of the boiling water being thrown at them? What would have been the better way? I'm just curious because I noted neither one of them backed away from what I could see, and I'm just curious what the training would be in a situation like that.
Well, such a great question. First of all, it's to get distance, especially when you're just looking at boiling water as being the intended weapon, apparently, that they saw as being threatening to them. So back away, get a position where something is between them, which there was already counter, but we see a lot of other items there, and talk to her and say, step away from that pot, please step away over here, and you need to get control of the situation in a very de-escalating manner. How they thought that it would be justified to pull a weapon when their life wasn't in jeopardy, nor serious bodily harm at that point because of the distance, really defies logic.
Appreciate both of you sharing such excellent insight with us. We know this case is far from over. We'll continue reporting any new information that we learn. In the meantime, let's turn to some other trending news.
Thanks to Julie Grant, who I'll be sure to hear from a little bit later. And like she said, we're gonna keep up with this story, and any more information that comes in, you can be sure the Bethea'S Byte Reloaded will have it here for you. All right, I'm gonna ask this question before I bring it up. A young child accused of killing her mom is about set to go on trial. Should the cameras be inside the covering? According to this judge, absolutely. Let's quickly go to Court TV and so they can tell you just how much the media has a right to cover this case.
Turning now to Mississippi, where defense attorneys are pushing for a case involving a teenage girl accused of murdering her mother and then attempting to kill her stepfather to be closed to the public. A motions hearing was held today for 15-year-old Carly Gregg. Prosecutors say back in March, Gregg, who was just 14 at the time, shot her parents and then invited a friend over to look at her mother's body. Well, the judge heard several motions, including a motion to exclude the public and media from the trial. The defense fears that continued media coverage of the case will ultimately impact potential jurors and witnesses.
Instead of trying to convince a jury, what you're actually doing is trying to change someone's mind. And as I'm sure we all have parents and kids, when somebody's made up their mind, it's almost impossible to get them to change it. And they don't care what the evidence says. They don't care what the testimony is. They've already gotten this opinion, and it's given this sort of improper notion of expertise in the legal proceedings that they understand and know what's going on, when they really don't. So it's important to preserve the defendant's right to a fair and impartial trial. And also it's important to protect the people who are going to come into court and testify about these proceedings, many of whom are children and adults themselves. Like, they shouldn't be subjected to online harassment.
Well, the defense lost that argument, and the judge ruled that court proceedings will remain open to the public. Carly is being held on $1 million bond, and she's being held in adult prison.
Yeah, she's being held in adult prison. She's 14 years of age, facing first-degree murder charges and attempted murder for the attempt on her stepfather's life. Prosecutors say Carly Gregg shot Ashley Smiley twice in the face and once below the chin on March 19th before inviting a friend over to look at the body. Smiley taught high school math at the school her daughter attended. Smiley's husband, Heath, told police that when he got home, he found Ashley on the bedroom floor. Greg was in the kitchen, he said, and aimed the gun at him, striking him in the shoulder. Again, now 15, the charges against Carly Gregg are murder and attempted murder. When we get more information on this, when we get more information on what's next in this case, I'll be sure to bring it to you right here. Next up, Brian Kohlberger. He's requesting a change in venue. Why? For his upcoming trial? He wants the trial moved to Boise, Idaho. Let's go to Michael Ayala and Court TV for details on this.
We turn now to the Idaho student murders case against defendant Brian Kohlberger. His attorneys filed a motion this week to move the trial to Boise. Now, they claim Kohlberger cannot get a fair trial in Latah County, quote, because of the pervasive, inflammatory, and often inaccurate publicity and the small size of the jury pool. Well, they wanted the trial moved to Ada County, which is about 300 miles away. Now, that's the same county, if it sounds familiar, where Chad and Lori Daybell were tried. Now, earlier this year, Kohlberger's team contracted a trial consultant and a change of venue expert to conduct a survey of 400 residents in Latah County to determine the impact of pretrial publicity on the community. Well, prosecutors tried to stop that survey, but Judge John Judge ultimately agreed to let them continue as long as it didn't violate his gag order. Well, Kohlberger is accused of killing 4 University of Idaho students in their off-campus rental home in November of 2022. Here's a look back at the victims.
On November 13th, 2022, at around 4 a.m., 4 college students were brutally murdered. Each would soon become household names, known for their deaths, but remembered for their lives. Kaylee Gonsalves, she was 21 and born in Concord, California. Her family describes her as sociable, strong, and a hard worker.
Kaylee was our middle child out of 5. She was always competitive. She was smack dab middle, so Steven and Olivia were a little bit older. And Aubrey were a little bit younger, so she kind of had to figure out where to fit in, and she definitely did.
Maddie Mogan, also 21, was best friends with Kaylee since childhood. Maddie's family says she was known for her offbeat humor and her ability to make others laugh and smile.
She was so great. She lit up every room she'd come in, and she was just so positive and fun, and we love her and miss her so much.
20-year-old Xana Cornoto grew up in Idaho and was a talented gymnast as a child. In high school, she played volleyball, track, and soccer. Xana was going to school for marketing.
Xana was such a light in my life and so many others, and she knew and understood me more than anyone. Losing her is the hardest thing I've ever had to go through, and it has left me heartbroken.
20-year-old Ethan Chapin loved sports and country music. He was Xana's boyfriend, a triplet who was incredibly close to his family.
We are eternally grateful that we spent so much time with him. And I want to remind you that that's the most important message that we have for you and your families, is to make sure that you spend as much time as possible with those people, because time is precious and it's something you can't get back.
As of right now, Kohlberger is scheduled to go on trial next June. The judge has set a date of August 29th for a hearing on that change of venue motion. That's being opposed by prosecutors. All right, still with me to discuss, civil rights attorneys Adante Pointer and Sue Ann Robinson. Sue Ann, I'll start with you. Let's put this on the table. You know, change of venue is not easy to get. Basically, you know, it's something that you need to show that this would really affect the rights of the defendants. Do you think they have a shot in this one?
Honestly, I think in this world today, the case is already an international sensation, a national sensation. It's bigger than the community already. So people already have so much information about the case. So the thing that they're trying to prevent by moving the venue could really happen anywhere, arguably, because people have information about the case everywhere. So typically the lawyer would argue, hey, this is a small venue, this is a small town, everyone here that's in the jury pool would be affected by this case and be unable to be unbiased. But that could prospectively happen anywhere in the information age, right, where everyone has access to information about the case.
Yeah, and that's basically what the state argues. They're basically saying moving it is not going to change the familiarity of the jury pool. This is such a widely publicized case. But that publicity, Adante, they claim in their, in the studies that were done by the folks that they hired, that it was emotion evoking, it was inflammatory, it was misleading, and it was not benign. And I do want to point out Moscow, where it would take place, 41,000 residents. Boise, almost 240,000 residents. Big difference there.
Absolutely, that's a big difference. I mean, you have about half as many people in one city as the other. The question really is, although the defendants, they've done a great job with the studies, but as any of us know, the way in which a question is asked will oftentimes impact the way in which it is answered. And so, although they have these polls and they have these studies, I would think the prosecution in and of itself would raise that point, but also as the other guest analyst raised, just because you move it from one location doesn't necessarily mean that you're going to get a less of an impacted or affected jury pool when you have a case of this magnitude. And frankly, all of this, the whole area is small town America. So this case has an outsized effect within that general community. And I just don't see a move from one to the other as being such a difference maker that it's going to impact the way in which the juries look at the trial and ultimately whether or not the defendant has a fair chance of justice.
Yeah, and to be specific, the defense must establish that there's a reasonable probability of prejudice to their client or to the defendant, Koberger, in this case. And there's a couple of other things that they cited, Swan, and these sort of touched home with me, that Latah is a very small, close-knit community. The surveys suggest that the community has prejudged the case, including conviction and death, and that major employers in the area are law enforcement and the University of Idaho. I found those to be particularly persuasive.
Those are very compelling facts for the defense, for them to put in there and say, hey, listen, not only is this a very small town, but a lot of the town actually has connections to the case. And I think that, it's going to come down to the judge and what they decide, but I think it's something that in any case has to be borne out during voir dire. The attorneys have to be able to look at the jurors and ask them the question, despite what you know, despite your life experience, are you going to be able to be fair and impartial? And they have to trust and believe in that, because that's the cornerstone of the trial system.
Yeah, no doubt. And I think another cornerstone of Dante is this idea that the community wants justice. So you do everything you can to keep it in that community. And so what role does that play in a judge's decision?
Well, I think it's definitely a factor. I think it's a heavy factor in the sense that the community wants to take part in meting out justice, being a part of this process. And so, I think the judge will give that a large consideration as a judge weighs the different factors before it.
The other thing, Swan, involves precedent. There's some very recent precedent, and we mentioned it, right? We have the Daybells who were sent out to Boise because of the same reason. And I would absolutely, maybe even higher. But, the publicity surrounding that case, very similar, and I think this case may even have more publicity than that one. And we know judges like precedent. And even though it is something rarely granted, that precedent may certainly help the defense as well.
Certainly. I think the Daybell case is a good example of a case where, changing the venue, the court decided it's better to be safe than sorry, better to let them have a different venue than have to put everyone in the community through the trial more than once, or possibly just have to do the trial again somewhere else because they go up on appeal and are successful. So I think the Chad Daybell trial is certainly good precedent for the defense. But again, it's going to come down to whether or not the judge thinks, listen, has the defense met these prongs? Have they met these? Do I feel like the jury here is not going to be able to be fair and impartial. And I think anywhere they go, they're going to have an issue. So it's a very tough argument to say, hey, if we stay here, it's not going to be fair in a situation where the trial is the information, the facts, everything about the case has been so widely publicized.
Yeah, fair enough. But at the end of the day, Adante, no matter how it turns out, it's good lawyering because it preserves this issue on appeal.
Absolutely. If I'm the defense, I'm vigorously fighting for this motion. I'm asking the judge, change the venue. I'm pleading with the judge to change the venue. And if he goes against me, I'm going to use that as my basis to come back around on appeal. So it is very good lawyering and it's strategy at its finest.
It's all part of that strategy. It's all taking place now.
All right, you heard it. Monday, they filed a motion to move his case to Boise, Idaho, because he cannot receive a fair trial in Latah County because of the pervasive, inflammatory, and often inaccurate publicity and the small size of the jury veneer. They're asking for the trial currently scheduled for June 2025 to be moved to Ada County, nearly 300 miles away, which is where both Chad and Lori Daybell stood trial. They'll be back in court August 29 to argue their positions for the change of venue. And, of course, Bethea'S Byte Reloaded, we're covering that. Next up, a mother and a daughter were charged on a murder plot in Idaho at an Idaho campground. Ooh, hold on. There we go. Alright. A mother and daughter are facing charges after a man was fatally shot at an Idaho campground. Court documents obtained by Scripps News Boise alleged 35-year-old Melissa Columpit. I'm trying to pronounce that name correctly. Melissa Columpit and 59-year-old Rosalie Morris admitted to plotting the murder of 37-year-old Travis Columpit. Travis was found dead at Martin's Landing Campground on July 12th. He had been fatally shot in the chest. Melissa and Travis were married in 2010 and have 2 children together, but the documents say the two were estranged and had previously divorced in 2018 and remarried in 2020. Melissa told investigators she was forced to leave their house in Parma in April due to Travis being physically abusive to their children. Melissa told investigators that she planned to meet with Travis on July 12 to inform him that she wanted a second divorce. Court documents reveal that Travis told his stepfather he would be meeting Melissa in hopes that they would repair their relationship and spend the weekend together camping. The prosecutors believe Melissa and her mother Rosalie had other plans. During the investigation of the shooting, Melissa gave detectives a detailed account of her activities on July 12th. Documents state dashcam footage from one of the vehicles at the campground captured Rosalie's 2003 Toyota Highlander parking in the area to meet with Travis. When the investigators presented the footage to Rosalie, she admitted that there had been a family meeting at her house in Nevada the day before, on July 11th, where she spoke with Melissa and 2 other individuals about how they could get rid of Travis for good. The affidavit says Rosalie also admitted that she planned to kill Travis on July 12th and told investigators she searched for an unregistered firearm to use in the murder. Rosalie reportedly told investigators that her initial plan was to make the trip to Martin Landing alone, but Melissa wanted to join her. Melissa reportedly admitted to investigators that she knew of the plot to kill Travis, and she told Travis to meet her at the campground alone. Documents state Rosalie hid in the campground bathroom while Melissa talked with Travis. Court documents indicate that Melissa changed her story multiple times while talking to investigators about what happened at the campsite. Initially, she claimed Travis raped her, but later she said she bludgeoned Travis with a rock and shot him when he charged her. In one version of the story, Melissa claimed that Travis took the gun and racked around into the chamber. According to Melissa, after Travis was shot, he pleaded with her and asked her why, to which she responded, "I'm sorry, I love you," before running away. Melissa says she took the gun and Travis's phone and asked Rosalie to take her to CJ Strike Reservoir. On the drive, court documents say she threw the SIM card out of the car window and tossed the phone and gun into the water. Melissa will appear in court for a preliminary hearing on July 26th, which that day passed, and will return to court on August 2nd. And of course, Bethea'S Byte Reloaded will be covering that case as well. There was a hearing ordered after a man released on bond allegedly murders his girlfriend. This is out of Nashville, ladies and gentlemen. A 6-panel judge has scheduled an evidentiary hearing after a man allegedly murdered his girlfriend while out on bond. 23-year-old Bryson Rivers is accused of murdering Lauren Johansson, on July 3rd in Mississippi. Just days before Johansson's death, Rivers was released on bond in Nashville, where he had been held after an alleged attack on Johansson. Last December, Rivers and Johansson took a vacation in Nashville. Police arrested Rivers after finding him lying on top of Johansson in a parked car. In that incident, Johansson had recorded part of the attack on her phone. Audio reviewed by Scripps News Nashville revealed Rivers accusing her of having relations with another man. In the 11-minute recording, Rivers seemingly taunted Johansson with graphic language, while recording depicted her gasps and cries. Body cam footage showed Johansson using her hands to bang on the passenger side window for help. An officer tugged the door open, and she ran outside into the cold night in just her underwear. Rivers was arrested, and Johansson, who was covered in blood, was taken to a hospital for treatment. Days later, he called Johansson from jail, allegedly instructing her what to say to investigators. Per the arrest affidavit, Johansson didn't want to press charges, but police said they had enough evidence to do so. Rivers was charged with 2 counts of especially aggravated kidnapping, aggravated stalking, and witness coercion. In April, Judge Blackburn lowered Rivers' bond from $250,000 to $150,000. Brooks bail bonding and on-time bonding split the cost of Rivers' $150,000 bond, and he was released on June 24th. An amended order stated that Rivers must wear a GPS device installed by Tracking Solutions in Nashville. He could not leave the county, and he could not have contact with Johansson. Court officials later acknowledged that an error by one of their clerks meant the Davidson County Jail did not have Rivers' bond conditions when he was released. That meant Rivers walked out of jail without supervision before calling Brooks bail bonding himself. Brooks bail bonding then hired Freedom Monitoring for GPS services instead of Tracking Solutions. The owner of Freedom Monitoring later told Judge Blackburn they were unaware of the judge's conditions for release at the time the monitor was installed, but insisted they set up zones for his device on June 28 when they learned of the order. That day, Rivers showed up to Brooks bail bonding, supposedly with Johansson. That's according to a report from Scripps News Nashville. Legal analyst Nick Leonardo said Rivers should have been put under arrest. Instead, just 4 days later, Johansson's body was found in her car 7 hours away in Mississippi. Police found Johansson after a call for a welfare concern at a local cemetery. Upon arrival, deputies encountered Rivers running from a vehicle into the woods. Mississippi agencies located Rivers several hours later and arrested him. Rivers was charged that same day with Johansson's murder and now sits in a Mississippi jail on $1 million bond. Now, a six-panel judge has scheduled an evidentiary hearing for August 15th, where representatives from Brooks bail bonding and on-time bonding are expected to give testimony. The courts are also requesting receipts, documents, emails, and photographic evidence of what these companies knew before Rivers left for Mississippi. Depending on the panel's decision, each of these companies could be suspended or denied the ability to write bonds in Davidson County. That's not taking into consideration any possible criminal liability these companies may face. That's another one I want to keep track of, and I will, and when I get more information, you'll get it here. Another Karen Reed update, ladies and gentlemen. This time there are 2 more troopers under investigation. Let's quickly go to Michael Ayala for this brief update on the 2 troopers that are
Two members of the Massachusetts State Police who testified in that high-profile Karen Reed murder case, which ended in a mistrial earlier this month, faced internal affairs investigations. The agency says the details of that investigation are close to the public. Both Detective Lieutenant Brian Tully and Sergeant Yuri Buchanan remain on full duty during the investigations. Meanwhile, Reed's retrial is scheduled to begin next year on January 27th.
And Bethea'S Byte Reloaded will be covering the retrial of Karen Reed once that gets going. Will this turn out to be another mistrial, or will we finally reach a verdict that will satisfy everybody and bring justice to the family of John O'Keefe? We will find that out in January. Next, a Uvalde police officer pleads not guilty to charges of failing to protect the children in that mass shooting.
Third, a former Uvalde, Texas school police officer who was part of the response team in the mass shooting pleaded not guilty to charges of failing to protect kids during that attack. Adrian Gonzalez was one of the nearly 400 law enforcement personnel who responded to the scene, but then waited more than 70 minutes to confront the shooter inside the school. Gonzalez was arraigned today on charges of abandoning and failing to protect children who were killed and wounded. Gonzalez and former Uvalde School Police Chief Pete Arredondo were both indicted by a grand jury in June.
And the operative phrase in this case is, you had one job. Now Gonzalez is being charged for not doing his job. I've got 2 more cases left before I go to Julie's opening statements for the week. I'm going to start right here with Scott Peterson. No, excuse me, I said I have 3 cases left. I'm going to start with Scott Peterson. His deadline is set in the DNA testing of duct tape. Let's go to that.
All right, right, folks, we have some breaking news. In the never-ending Scott Peterson case, the convicted double murderer, a California judge has granted the defense's request to test a piece of duct tape recovered from Laci Peterson's remains for DNA. The tape was recovered during Laci Peterson's autopsy in 2003. Peterson was convicted in 2004 of murdering his pregnant wife, Laci, and their unborn son, Connor. Earlier this year, the Los Angeles Innocence Project attorneys requested access to test evidence for DNA. Peterson has always maintained his innocence, and the jury maintains that he's guilty. The LA Innocence Project lawyers believe the evidence could clear him of the murder conviction. Peterson is hoping for a new trial. He's currently serving a life sentence without the possibility of parole. And I remind you once again, their theory is that someone was burglarizing the house across the street. Laci was walking the dog. She saw the burglars, so they abducted her and then murdered her and then put her in San Francisco Bay, where coincidentally Scott Peterson went fishing that morning.
We'll find out eventually if Scott Peterson will get that new trial that he's seeking. Or better yet, maybe even cleared. Next up, superstar Justin Timberlake and his lawyer saying that he was not intoxicated when he was arrested for DUI. All right, back to Vinny.
Welcome back. Time to reveal something else you need to know tonight. Let's take a look at a big DWI denial by Justin Timberlake. Unbelievable. So there was a hearing that happened, and I want to read the statement from Justin Timberlake's attorney. The most important fact to know about this case is that Justin was not intoxicated and should not have been arrested for DWI. The police made a number of significant errors in this case. Sometimes the police make mistakes, and this is just one of those instances. Justin respects law enforcement and the very important job that they do, but the fact remains he was not intoxicated, and they made an error in arresting him for it. We are confident that this charge will be dismissed. So is what they're saying that the charges will go bye? We'll stay on top of it.
Man, Vinny, that was bad. But that is the lingering question. Will those charges go bye? We'll have to wait and see as this case progresses. But as it stands, Justin Timberlake's lawyer is saying that the pop superstar was not intoxicated when police arrested him for DWI. All right, guys. I promoted it this way, so I saved the best, or should I say the worst, for last. Here we go with Sarah Boone's case. Now, while I am I'm setting everything up so you can get all of this, but there is one thing I want you to see. So if I can get my folder open, hold please. Oh yeah, there we go. Oh boy. There is one photo I want to show you guys, but I want Okay, at least that's open. Okay, let me go ahead and get that set. This goes to here we go, here we go, here we go. Right. Alright. Okay, guys. Now that I'm set the way I want, to be set, I'm gonna take you right into the courtroom right now. First off, we're getting this coverage from Court TV's Ted Rollins. This guy, we're gonna go right into the courtroom for the surprise hearing for Sarah Boone.
We're following new developments in another case in Florida, the suitcase murder trial for Sarah Boone. The defendant appeared in court yesterday and was very upset that she didn't get more warning about the hearing. She's representing herself now after she went through 8 separate attorneys. She was also not happy that a news crew from the local Fox station found out about the hearing before she did.
If we have to set a hearing, you'll be properly noticed for it.
In the certificate of service.
You'll be properly noticed for it, yes ma'am.
And will there be a proper notice for today?
Notice was performed last night. I've
Am
already
I allowed to ask
explained.
the news crews how they got here?
No ma'am, I'm not gonna let you do that. They're not under oath. They're not a party to this action right now.
It's wrong and it's unfair.
You're certainly entitled to that opinion.
Sarah Boone has advertised for a new attorney. She concocted this flyer and wanted it posted at the courthouse. She's accused of killing her boyfriend, Jorge Torres, who died after being locked inside a suitcase, a case we've been watching for a very long time. It's a horrifying case because there's video of Jorge in the suitcase and she is communicating with him. He's saying, "I can't breathe, Sarah, let me out." And she says something to the effect of, "Well, you should have thought about that when you were cheating on me," and then would later tell police she was drunk, fell asleep, found him dead the next day. Joseph Tully with us. Representing yourself is very difficult business. We've seen people attempt it, and very few are successful. She's gone through 8 attorneys. We had someone on a few weeks ago that said she's mentally off. She's and this is a sort of a sad, just parade of events now. Losing the attorneys, her coming in. What's your take when you look at this case and you look at her behavior since she was arrested?
So I agree. I see the same thing. I see mental health issues very present in this case, and it is sad. I think that this tactic of going through 8 attorneys, just because somebody has mental health issues doesn't mean they're stupid. They could be intelligent, but it's not like other people haven't thought of the same tactic of just keep pushing the trial off by blowing through different attorneys and you'll never get to trial. But at some point, judges get sick of that. So that's what I think is going on. And then I agree with you that the evidence looks pretty strong against her in terms of the videos and her communicating and then her subsequent statements to the police that don't really match up with what we see on video.
Here's another interaction with Sarah Boone yesterday and the judge.
I am thoroughly confused. Was a notice ever put online for this or mailed to anyone?
Okay.
I don't even know why Mr. Lane is here. I don't know why I'm here.
Well, ma'am, you are now representing yourself, and previously you had requested to appear at every hearing that was held. As you are now representing yourself, the court cannot have any hearings regarding your case without you being here.
Daryl Brooks represented himself, Joseph, and we watched the judge in that case sort of play good cop, bad cop for weeks. It was very difficult, but she was able to coach him when he needed it, because no one's going to be able to be able to perform as their own attorney without some guidance. What do you think we're going to see play out? And if you're the prosecutor, how do you handle that, watching the judge and maybe the prosecution helps out at times, because she's going to need some help, right? Correct?
Sure. Yes. This is a very tenuous situation in terms of she won't accept an attorney. So she's in this position where the judge is kind of forcing the issue, and which means she has to represent herself. She's not qualified. There are mental health issues going on. If it goes to trial and she receives no help, it'll be overturned, you know, because it'll just be a clown show, basically, for lack of a better word. And so they have to kind of prod her along. I think this affects the prosecution in that the prosecution can really just relax, soft sell the case, and let the accused kind of sink herself here in front of the jury.
Yeah, good point. It should just let her be her, and that'll play out the way it does.
Like I said, if this wasn't real, this would be funnier than what it already is. This is the same woman who has went through 8 attorneys, 8 of them, and now is looking forward, or at least trying to get to attorney number 9. Now keep this in mind, though. Keep this in mind. The first 8 attorneys were doing was trying to help her. Then again, Defendant Sarah Boone must have been the smartest person in the room, because apparently those first 8 attorneys, they weren't able to do the job for her. So the judge said, "Okay, 8 is enough. You're done. You want to handle it? Handle it yourself." And let me remind you all, in case you miss my commentary on this around the YouTube streets, let me give you a subtle reminder of a defendant's record in defending themselves and representing themselves and being able to get an acquittal. Defendants in criminal trials are old and forever. There has none that has won their case like this. And I believe deep down in my heart, when the trial starts for Sarah Boone, and it will start, no matter how much he tries to stonewall it, the trial will start. And I believe deep down it's going to be another one in the defense's loss column. All right. And speaking of that one ad, Julie Grant, in one of her opening statements this week, asked the question, what lawyer would answer Boone's want ad? I mean, I'll stretch that question another further. Who in their right mind would want to answer that want ad? So, what I'm going to have you guys do as I set this up is get yourself prepared because it is now time for the first of Julie's opening statement.
An epic opportunity awaits. That's according to criminal defendant Sarah Boone. The woman accused of murdering her boyfriend, Jorge Torres, by locking him in a suitcase, is advertising for a lawyer. Yes, she created a help wanted ad of sorts where she describes the job of representing her as an epic opportunity. She's looking for a lawyer to represent her now after all 8 of her previous lawyers were unacceptable. What I want to know is how she's going to handle the rush of applications. I mean, how's she going to get through them all? I'm sure so many lawyers are anxious to work with such a peach of a defendant. I took a look at that ridiculous poster, and all I could think to myself was, is this woman serious? I hope the court orders a mental health evaluation. I'm serious when I say that, because I think she ought to be evaluated after this most recent absurdity. Because if she's not having mental health difficulties, then she is just plain obnoxious. It looks obnoxious that she drove away 8 excellent lawyers. And now she's hoping that number 9 is going to be the perfect fit. I think they all deserve a medal for tolerating her. And I think the judge deserves one too. Jorge Torres was killed on February 25th of 2020. 2020. The judge was right to say enough is enough and have her represent herself, because this would keep on going. My friends, in my opinion, it's time this case goes to trial. And it is time the attention gets put in the proper place. And that is on the victim, Jorge Torres.
I couldn't have put that any better. I mean, Sarah Boone has stalled and stalled and stalled and stalled, and the judge said it best. Enough is enough. If the first 8 attorneys aren't going to do for you, you can forget about number 9. There is a rule to this, and the rule is very simple. If you want it done right, do it yourself. And Sarah Boone is asked to do exactly that. Do it herself. On Tuesday, Julie had to break down the fact that Marsha Thompson was found not guilty in her trial, and she called that a vindication. So we're gonna hear from Julie on that one. So hang tight. This is the second of her opening statements.
Not surprised. I am not surprised that the jury found Marsha Thompson not guilty. Only because I understand what trauma can do to the brain if it isn't properly dealt with. Let me be very clear here. There was nothing wrong with this prosecution. The state attorney's office should hold its head up high for pursuing this case. A fine job they did, following the evidence, following the law, seeking justice for Terry Thompson. Marsha Thompson was put through trauma after trauma after trauma and never healed. Her brain became wired differently than a person who isn't experiencing intimate partner violence. Her case illustrates the complexities of the effects of domestic violence on a person's mental health. My greatest wish for Marsha Thompson is that she can start on her healing journey now and take her children along with her. Intensive trauma-informed therapy is what she and her kids will hopefully receive as they go back to living as much of a normal life as possible. The court case is closed, but the healing journey, my friends, is something very separate. And we don't often hear people talking about the importance of healing when they've been through a trauma. But it is critical to understand if we want to help others or help ourselves break the cycle of abuse. Because the body isn't the only area dangerously impacted by domestic violence. Unhealed mental and emotional trauma can have devastating, and as we've seen, even deadly effects.
That it can, and I remind you once again, and if you or someone you love is a victim of intimate partner violence, battered spouse syndrome, or whatever the case may be, you do not have to be. You do not have to be a victim, and help is a phone call away. You're once again asked to call the National Domestic Violence Hotline. That number is 1-800-799-SAFE. 1-800-799-7233. There are folks waiting to talk to you. They're available in over 150 languages, and they're available 24 hours a day, 7 days a week. From one who was vindicated, not just acquitted, but vindicated from being an abusive an abused spouse, to one where Julie says she doesn't look like she's been abused. Julie's gonna go over the Black Swan's testimony. And basically she's saying that that it's Ashley, not Doug, who's shown signs of being the abuser. So here we go with the third open.
He's unarmed, she's uninjured. Was it murder or self-defense? Do you believe the Black Swan was abused? I've got lots of questions this morning, my friends. I know that domestic violence is about power and control, where the batterer uses violence to control their partner. So far, and I know it's early, but so far, doesn't sound like Doug Benefield was the one exerting the control. The defendant was doing what she wanted, living where she wanted, parenting their daughter alone as she wanted, deciding to stop speaking to him when she wanted. Doesn't sound like the Black Swan was being controlled with violence. I'm wondering if perhaps the defendant was controlling Doug with emotional abuse. Trying to keep him away from their baby, maybe? Cutting off communication with him, maybe? Was she abusive to him, possibly in that way? Domestic violence victims are generally very scared of their abusers, and rightfully so, living in a constant state of fear and hypervigilance. Now, if the Black Swan was truly afraid of her husband, why would she be alone with him? Let him help her move. Ashley Benefield's attorney says that Doug got in a warrior pose. He even demonstrated it in the courtroom, the warrior pose, and said he was advancing towards her. The defense is that she had to shoot him or else be seriously hurt or be killed herself. To get answers to my questions, I'm most looking forward to seeing the forensic evidence of how that shooting occurred. Because the prosecutor said that the bullet trajectory analysis showed that Doug was not coming towards her or even facing her when she opened fire. So I want to see what the science proves. Because people can tell stories, right? But evidence that can't speak to us can't lie to us.
And that's always been the great thing about evidence. The evidence that shows up in cases, they don't and can't lie. All right, finally. Oh yeah. Julie is gonna give another judge his flowers for taking control of his courtroom, and the defense attorney for Ashley Benefield is, in his own words, gonna get a whooping. So get set and ready, folks, because this is Julie's final opening statement of the week, and let's just say the defense attorney in the Ashley Benefield case deserves every last bit of this one.
You tell him, Judge. You rock. If you missed it, in the most poised, polished, professional way, the Honorable Matt White admonished the Black Swan's defense attorney for his disrespect. And my friends, I was here for it. The past 2 days, we have seen that attorney make snarky comment after snarky comment, many of them right after the judge has made his rulings. That is so improper and so disrespectful. That's not how the system works. When the court makes a ruling, you respect the court's ruling. You don't get to make snide remarks and continue arguing and criticizing the judge. No, you show respect for the court, for the courtroom decorum, for the opposing counsel, for the witnesses, for the jurors. You show respect to everyone at all times. As a lawyer, you are an officer of the court, and you must conduct yourself accordingly with the rules of professional responsibility, the rules of criminal procedure, and the rules of evidence. That is your job. I loved seeing that judge put that attorney in his place, especially with the way in which he did it. I mean, my friends, it was beautiful. I mean, he didn't get mad, he didn't raise his voice, he was just very calm and very respectfully reminded him whose courtroom it is and who runs the trial. And as my great-grandma would say, that attorney thinks he's the king, but he doesn't have a crown. The man wearing the black robe, sitting up on that bench with the gavel, he is the king of the courtroom. And Judge Matt White showed the world on Wednesday why he is so deserving of that position of authority.
And in the words of former undisputed WWE champion Roman Reigns, that judge told that defense attorney in no uncertain terms to acknowledge me. Show me my respect in my courtroom. That's all that was. That's all that needed to be said. Ladies and gentlemen, I'm done for the night. It's good to have you here in prime time. Let me remind you all just exactly where you have been over the last few hours. This is the drama-free true crime destination. This is the home for true crime news without all the drama, where your opinions matter, where lively debates are encouraged, where your voice is heard, and above all else, it's justice served. This, my friends, is Bethea'S Byte, and it's reloaded. Thank you all so much for joining me. If you like any and everything that you saw on this evening, let me know about it. You got like I called earlier. I'm all over social media, Facebook, X, YouTube, Instagram, TikTok, and email. You can always get a hold of me. All right, I'm out of here, guys. Thank you all so much. And until we do this again, you all know what to do. Bite this. Thanks for watching and joining me here at the drama-free true crime destination. Be sure to like, share, subscribe, and drop me a comment on this video. And be sure to follow Bethea'S Byte Reloaded all over social media. This is Bethea'S Byte, and it's reloaded.